whatever included in the modules. Online thing.
Oh, so
Right. So anyway, right. Social, as far as social security is concerned, Krishnima, right? Next time when you make a develop karna social security වලට දාන්න overview එකක්. social security කියන මේකට කලින් ඒකේ overview එකක්. ඒ කියන්නේ ILO convention එකේ තියෙනවා 102 9 branches. ඒ 9 branches වලට ලංකාවේ කොහොමද social security හිමි වෙන්නේ මොන අයටද කියලා. එහෙම එකක් දාන්න. Because I was doing it, we had a couple of series of programs before this, the election, right? Under the Jayagamu Sri Lanka program. Presentation එක මං හිතුවා share දීලා කියලා ඔයගොල්ලෝ. කො share string ගිහිල්ලා නැද්ද? minimize කරන්න ඕනේ මේක. Share. හරිනේ? දැන් ඉතින් මේක මේ ගානටද පේන්නේ? ඒගොල්ලන් ලොකුට පේනවා නේ? right. Come. දැන් මට පේන්නේ නැහැ. මට පේන්නේ. දැන් හරිද? Right. Good morning, everyone. Right. Is the presentation visible?
Yes,
Those
sir.
who are joining online, is the presentation visible?
Yes, sir.
Presentation එක පේනවද?
Oh, sir.
I'm asking the online participants, please let me know.
Yes, sir.
Do you see the presentation? Do you see the
Yes, sir.
presentation?
Yes, sir. Yes.
Anyway, right. So, workman compensation ordinance, this is also comes under the social security, yes, right? But in our, the classification, the Sri Lankan classification, under the Sri Lankan classification, it comes under occupational safety and health. But anyway, as per the ILO Convention 102, this is also one of the, the branches of social security, right? The right, Workman Compensation Ordinance number 19 of 1934. The Workman Compensation Ordinance of 1935. Sorry, some mistake, right? Workman Compensation Ordinance, not 1934, right? 1935 what? A mistake. 1935 what? Yeah, but this one, trade union ordinance. Right. Okay, anyway, right, this is some mistakes, right? With the Workman Compensation Ordinance of 1934 actually, and subsequent amendment is to provide for the payment of compensation to workers who are injured in the course of their employment by an accident arising out of the and during the course of their work. So this is for what? In 1930s, the plantation sector was growing. Tea, rubber, and coconut mainly, and cinnamon as well. 1930s. It was started long back ago, but the majority of the significant number of people were working in this industry, and a lot of accidents were taken place. These are not this ordinance at that time. We didn't have much, the expanded service sector. We had the plantation and small light engineering in order to protect them because a lot of accidents were taken place. So that is why the objective was to protect them. Right? That is why you have to understand, you know, a law or legislation is enacted not just for the for the sake of enacting it. You need to understand the context, economic situation of that, economic and labor market situation at that time. At that time, Sri Lankan labor market or economic situation, as far as the economy is concerned, lot of plantation sector were prominent, the government, and uh, jungles. People have to work in jungles, right? In hazardous situation. So therefore, in order to protect them in terms of occupational safety and health, this legislation was enacted. Okay, this is not 19. If you have what do you call this, the presentation, I think they will be right. So make it correct 1934. So what was the objective? To provide for the payment of compensation to workers who are injured in the course of their employment, in the course of their employment by an accident, not only accident, the diseases as well. Later it will come, right? Arising out of and during the course of their work. During the course of their work. What does it mean? How do you understand the during the course of their work?
Within the period of employment.
Within the period of employment, it has been limited to workplace. Workplace. In the course of their employment. Not, say for example, what happened in the course of their, you are working in an asbestos company, right? You are exposed to kind of a chemical, whatever, right? Dust and things. Later, you will have, negative impact like lung problems, whatever, right? And can it be linked to the course of your employment?
Yes.
Yes. Classic example, have you heard about? Uh, what was the big company? Uh, Asbestos, maybe I know other company. And like that. Answer. We had a case. The person, but it couldn't be proved later because exposed to asbestos itself. Right? A person got sick, some lung problems, and then later the trade union, the person, right, who's a member of the trade union, they went to court. Yes, you're correct, but it has to be. When it comes to disease, it's very difficult to prove. very difficult to prove. When it comes to disease, this ordinance not only covered accident, the disease as well. But always, when it comes to disease, the health matter, the employer has advantage because proving it is somewhat difficult. But accident, yes, on the spot. Accident can be proved because you lose your finger, arm, whatnot, right leg, eye, it can be proved. Okay, but remember, this ordinance covers both, and also this ordinance, this is the one. There are 60 legislations. There are more than 50, but when it comes to practical implementation, there are 16 legislations in this country. There are more than 50, but in day-to-day activities, the others, dead now. But 16 are active and being implemented in day-to-day activities. Out of these 16, 14 legislations are being implemented by the Department of Labor. The Commissioner General is the competent, the Labor Department is the competent authority. Other two legislations are being implemented by some other institutions. ETF Act. ETF, Employees Trust Fund Board. Trust Fund. It was under the Ministry of Labor long back ago, but now taken away and now under the Ministry of Finance.
Under the central bank or?
No, the Ministry of Finance. Central bank is independent of it. Not central bank. It's Ministry of Finance. The other piece of legislation, this is implemented by the workman compensate the office of the workman compensation. Office of the workman compensation, which comes under the Ministry of Labor. Previously, it was under the Ministry of Justice, but now under the Ministry of Labor, not under the department. It's a separate institute like Department of Labor, but only the one piece of legislation is being implemented. The Commissioner of Workmen Compensation comes under the Ministry of Labor. So this is that, and we are going to discuss this one today.
So Ministry of Labor doesn't come under Ministry of Department of Labor doesn't come under Ministry of Labor.
Why not? Meaning under the Ministry of Labor, there are plenty, large couple of organizations. Workman compensation is one of those. Right? Under the ministry is the top one. Right? Under the ministry, the Labor Department is the biggest organization, and Department of Manpower and Employment, right? Sramavasana Fund, Office of the Workman Compensation. Before this new government, right? Previously there were 9 organizations under the Ministry of Labor. Now it has been reduced, right? But ministry is the top, and under the umbrella of the ministry, there are a couple of organizations. Office of the Workman Compensation is one of them. The commissioner is appointed by the Judicial Service Commission, because the commissioner of workman compensation is considered an additional magistrate, but she has to work under the Secretary of the Ministry of Labor. She is supposed to report to the Secretary, Ministry of Labor, even though she is appointed by the COE, is appointed by the Judicial Service Commission, but under the Ministry of Labor, she is the commissioner is supposed to report to the Secretary, Ministry of Labor, right? So This is, let me move to next one. The Workmen Compensation Ordinance number 19 of 1934, not 1935. And there are a couple of amendments time to time. The latest amendment was Workmen Compensation Amendment Act. Why is it Act? Why not Ordinance? Yeah, very independent, right? But the principal enactment is Ordinance, right? Principle. And 2022, the objective, how do you identify the objective of any legislation? Objective means what? You have to look at the preamble. Preamble. Preamble expresses the objective of the ordinance. So it says an ordinance to provide for the payment of compensation to workmen who are injured in the course of their employment. In the course of their employment. You have, you know, you will, I mean, later, maybe after break, the definition of workplace, right, has been expanded under 2022, right? I mean, whether it is okay or not, right? An argument. So you will have it right later. So, and then applicability of the ordinance. Applicability. Workman, any person who has entered into a contract, express or implicit, or implied, oral or in written, with an employer. You have learned this, right? Previously, the contract of employment, right? In Sri Lanka, the contract of employment, could it be in writing, in written? It can be verbal, express or implicit as well. Right? Workman. And person who has entered into a contract, express or implied, oral or in written, with an employer for the purpose of his or her trade or business. Trade or business. Even persons who are contracted for certain time or persons under apprenticeship are also included. Apprenticeship under other laws? No. But when it comes to occupational safety and health, yes. Contract, whatever. And also, this is, look, the exceptions, there are some exceptions. Members of armed forces, they have been exempted. Members of police have been exempted from the application of this ordinance. Why? I don't know.
So are they covered by any other name?
They have. Employer, Republic of Sri Lanka. What does it mean?
That is for government.
This is applicable for government or public servant as well. There are only 2 legislations out of 60 are purely applicable for pure public servant, pure public, not semi-government, right? Pure public servant. What are those? Trade Union Ordinance and Workmen Compensation Ordinance. Other legislations are applicable for semi-government workers in the semi-government organization. I'm talking about the pensioners, pensionable, pure public servant means pensionable. This legislation is applicable for them as well. But do you think that the public servant, pure public servant, right, are they applying for the compensation under the, compensation under the Workmen Compensation Ordinance? No. Why? They have more benefits under the establishment code. Ayatana Sangrahayana. They have more benefits than the benefits granted under the workman compensation. That is why they are not, you know, running behind this ordinance to claim benefits. More benefits or favorable benefits rather are there under the establishment code.
You can give few.
You know, few in the sense, we have to look at, the establishment code, right? There are sections. There is a section. If you got sick, right, you will get, say, for example, right, up to, I don't remember exactly, but up to 6 months, up to 3 months, the full payment. Right? And for another 6 months, our payment. Likewise, you have more benefits. And then if you, I mean, totally inactive, right? If you are, say like, you can't work. So then there are some other benefits as well. Benefits in the sense, if you work for the private sector, you lose the job, you will be compensated according to the Schedule 4 formula. I will let you know the Schedule 4. There are no schedule. There is a schedule. Maximum, how much you get? 2 million. Previously, it was 0.55 or 550,000 previous. Right? In 2022, it was amended and increased up to 2 million. But in order to get the 2 million, in course of death, right? In order to get 2 million, your salary, last known salary, should be at least 100,000. Look at the ordinary people. They're not getting 100,000. Their compensation is somewhat less. But if the person working, the public servant, they have 3 months salary, right? Based on the medical report. Another, there is a procedure. You can go around, 1 year. That is the benefit. That is why the public servants are not claiming benefits under the workman compensation ordinance. It's a one-time payment. One-time payment. In course of death, just 2 million maximum. Right? Okay. Sometimes, some people I have observed, they are applying for both. They have, I know one case. And then at that time, I was the Commissioner General. But still, there is a possibility for them to get benefits from both sides, public and this one, because there is no cross-check. Public administration doesn't know about that. That is the problem. Public administration, when they apply, no one knows, and the same person apply under this one as well. There is no cross-check. Even the public administration people, they don't understand this. When I was, I was arguing with some DG establishment. ඉතින් මිනිහා කියන නෑ සර් එහෙම වෙන්න බෑ. මං කිව්වා ඔබ කියෝපන්. ඔක සිංහලෙන්ම කිව්වා ඔබ කියෝපන් මේ පනත අරගෙන. ආයතන සංග්‍රහයත් අරගෙන. So anyway, right. So public of Sri Lanka, anybody incorporated or not, it's a private sector, and hires, again, hire කරන අය, right? Executors of a deceased employer. Come. දුර ඉඳලා එන්නේ නේද? Where are you coming from? Where? Negambo, Kochi. Coming by bus. Okay. Who is so the payment is so who is entitled? The workman. How the workman has been defined? This a person who has is the any person who has entered into a contract or work with an employer, whether apprenticeship or contract, whatever. So the workman is entitled. Then you have to look at it. We can't say just that person, this person. We say workman is entitled for workman compensation. Then ask who is workman? Workman is this. The definition, right? The payment is calculated by time or work done. Or otherwise. The ordinance considers period of service as a continuous period which has not been interrupted by a period of absence from work not exceeding 14 days. What does it mean? The payment is calculated, okay, right? The ordinance considers period of service as a continuous period. Akanda Sevakara. As a continuous period, which has not been interrupted. අකණ්ඩ සේවා කාලේ ඉන්ටරප්ට් වෙන්නේ නැහැ. ඒ කියන්නේ දින 14කට නොවැඩිනවා. දින 14ක් වැඩෙන්න පුළුවන්. Right? Which has not been interrupted by a period of absence from work not exceeding 14 days. දින 14කට වඩා වැඩියෙන් absent වෙලා නැත්නම් ඒක තමයි ඒ කියන්නේ 14කට වඩා වැඩි වුණොත් ප්‍රශ්නයක්. There is a problem. Otherwise, a continuous period is considered. Okay? The law applies to government departments or ministries or government servants and local police as well. And in the case of workmen who are matters of registered ships or seamen, subject to certain modification detailed in section 25 as per part 4 of the ordinance. This is not actually applicable because they are not applying, seamen, seafarers, we call it seafarer. This is the wordings, the ordinance, has a stipulation, but we call it seafarers. So seafarers, they are not. They have, insurance, whatnot, right? The big money. This is now. First of all, let me tell you, in 1934, at that time, Workmen Compensation Commissioner was just an administrator, the public servant. It was not a lawyer at that time. Because this was elected in order to compensate affected person immediately, as soon as possible. Now, it has become a court. Workmen Compensation Commissioner was appointed just from the administrative service who can understand the subject and to grant relief as soon as possible. Just check and looking at the situation and grant what do you call this, the relief. Now it has become a court. Yeah, not arbitrator. Arbitrator is something else. Right. It has become a uh, just like magistrate, MC. The police is coming, the guard is there, and the lawyers are supposed to be appear. Not only lawyers, there are trade union representative as well as per the amendment into very recent amendment. It has become a court. උසාවිය නිශ්ශබ්ද වෙනු. But the objective was not that. In 1934, the objective was to grant immediate relief for the affected person. It was not a court. Now, why it has become a court? Because now the commissioner is appointed from the Judicial Service Commission. The Workmen Compensation Commission and LT President have been titled, or title has been granted to them as additional magistrate. This is the problem. How an ordinary man who has been affected by way of accident or disease, he or she has to, it's like a court, hire a lawyer, dragging. Maybe compensation 40,000. If it takes 4 years, what is the purpose of going behind this? I tried my level best to abolish this institution and make it compulsory. What do you call it? Insurance. Compulsory insurance. I wanted to bring, during my tenure as the Commissioner General, I asked the Korean, Korea is the very best, the best country in terms of occupational safety and as far as the benefits are concerned. I brought them, I discussed with the trade union, workshops were conducted, but failed. This is compulsory. But compulsory in the sense, what? If you met with an accident in the course of your employment, you are, eligible to get the benefits under this ordinance. But look at the cost side. The benefits say maximum 2 million, maximum, in course of death. Right? So then, in order to, if the employer refuses, then it is dragging like a court. The employer refuses, it may sometimes take 5 years, 6 years to get the relief. Then how much you have spent for lawyers? Your family, no one knows. And what is the value of 2 million after 5 years? So therefore, on the spot, right, insurance, the power could be granted to Commissioner General of Labour. Right? Check it, okay, pay it. Like the insurance. The employer also, have no problem. But now, many officers, the commissioner's salary, the salary in the sense not the basic, right? Even higher than the secretary's salary. COE is coming under the secretary, Ministry of Labour, but higher than, because of the judicial, they just They try to, maintain, some kind of a, that is the system in Sri Lanka. Judicial people, they think they are the superior. If police does not implement the order, police implement them. Very not the monopoly. වෙනවා. එනිසා ඒගොල්ලෝ දැනගන්න ඕනේ. ඒගොල්ලන්ගේ ස්ටේටස් මේන්ටේන් කරගන්න නම් හැසිරෙන්න ඕනේ. ලංකාවේ නැත්තේ ඒක. So ස්වාමීනි කියලා කියන්න ඕනද ස්වාමීනි? කොයිද লীලා තියෙන්නේ කියන්නේ? ඔයවත් නැහැ. We respect to the court, not to the person. We respect. අර කාන්තාව මතකද අර නළුත් මේකක්ගේ මීගම්මේ හරි කොහේ හරි අර ලෝය කෙනෙක් ස්වාමීනි කිව්වේ නැහැ කියලා. උසාවියට මේ නම ආචාර කරේ නැහැ කියලා. එයාගේ මොකද්ද ජේල් එකේද දැන්නේ? ජජ් කෙනෙක්. ඊට පස්සේ ෆොටෝ පැපිල් එකට ගිහලා මේ මෑත මාසයක් නැහැ. ෆොටෝ පැපිල් එකට ගිහිල්ලා ඒ ජජ්මන්ට් එක අයින් කරා. ඒක ගේස් දුන්නා කියන්නේ. එහෙම මෙන්ටැලිටි එකක් තියෙන මිනිසුන්ට. මොනවාද අවුරුදු 5ක් ලෝය කෙනෙක් හැටියට පැත්තේ කටපාඩම් කරලා ඉවරලා විභාගෙ දිවුවාම මැජිස්ට්‍රේට් විභාගේ පාස් වෙනවා. ඊට පස්සේ එතෙන්ට ගියාම හැසිරෙන්න වෙන විදිහ. එහෙම මෙන්ටලි උසාවියේ ස්වාමීනි කියලා කියන්න කොහෙවත් නැහැ. my lord කියලා කියන්න එහෙම කොහෙවත් ලියලා නැහැ පොතේ. I'm not a lawyer, but my daughter is a lawyer. එයා තමයි මට කිව්වේ එහෙම කොහෙවත් නැහැ ලියලා නැහැ. But we must respect to the court. It means that justice. යුක්තිය හා සාධාරණත්වයට අපි ඒක ඉටු කරන්නේ අධිකරණය. Judicial. So we respect, not to the person. Not to the person. Alright, okay, anyway.
In case, most of the companies have insurance policies.
Yes.
For their employees. So then in that case, can an employee get that insurance cover as well as employee?
No. The most, the big companies, they have given, the insured, the workers have been insured based on this workman compensation ordinance. Right? We are not supposed to take, both. Insurance means most of the companies just not, they may have medical insurance, but they have insurance. The workers have been insured by the companies, big companies, right? To make the payment to give the benefits in the course of, the injury or whatever it is, occupational safety and health, based on the formula of the ordinance.
But can give a higher amount.
Yes, but minimum is most of, is kind of a, I was told by, at that time, now මොකද සෙල් එක කලින් සෙල් නෙමෙයි කලින් තිබුණේ මොකද ඔගේ නම සෙල්ද නෑ මොකද දැන් තියෙන්නේ මේ ලිට්‍රෝනේ දැන් now it's litro previously cell right cell CEO right I met him because he was from my service right cell is and he retired prematurely and joined with the cell as CEO. And he was telling me that it's kind of a 0.08 or 0.006, something like that, from the payroll, the usual premium. So very less. It's easy. Yes. Well, you will learn it later.
So when the person is injured, she is going to get leave. So for that period, the company pays the salary. Can the company deduct the amount from the workman's compensation check? That is legal?
No.
But still, if the person has no.
So let me. Oh, yeah, yes.
No no level of income
Okay.
until he or she gets, if it's a month of 3 months, so they have no source of income and they are on leave, they have no way to work. In
Okay.
that case,
If the person has been insured, right?
and the payment is that paid by the company.
Okay. Insurance premium has to be paid by the, because the liability comes on the employer, no? Right. So insurance check is written in favor of
The company.
the
Contract.
right. So compensation, the basic thing you need to understand. Compensation is paid according to the formula of the workman compensation.
Directly goes to employee.
Basically, mainly goes to the employee. You have paid because of the sentiment, the sentimental. So, by it's kind of what a sympathetic ground. So, you cannot deduct any single rupee.
So the payment is twice for that. If the person is given the full salary, and for the loss of period also the salary is calculated. So the check is given for the loss of period. So it's twice of the
Uh,
payment is all. He or she receives the payment double.
so then, right, yeah, your argument is correct, but where in case
This was lower in
there is no law written, right? In case the person goes to court or complain to the commissioner, workman compensation, I was not paid, I was not compensated the exact amount. Then what will?
so we have paid the salary for some amount, period. Or
But you are trying to defend the mistake that you have done.
so can we stay without paying the salary until?
Why not?
Okay.
Yes, because if the person is not coming to work,
Yeah, but usually has happened inside the company
yes,
that
inside the company,
company
right?
is
So, say for example, is a minor thing. Say the hand, right?
temporary labor.
Temporary, right? Say the person cannot work for 3 months, right? As per the medical, report or whatever, and then you pay, right? Monthly salary say 50,000, 50,000, 150,000. If the compulsion is less than 150,000, what will?
So usually it gets more than that because the full salary is given calculated to 12 months. So usually the, if it is sometimes the exact amount or else more.
You know, it's good, right? From the point of view, the worker's point of view, it is good.
So there's a case that one of our workers has
Oh,
been injured.
okay.
According to the medical report, she can't work for 3 months.
Okay.
And now she got recovered and she's back to work. And we got the insurance check. And so we have paid for a salary of 122,000. So, and the check is around 140 something. And we have paid her the transport and everything. And she has no way of income, no source of income. So because of that, we have
I
paid.
understand your point.
And the company says now we have paid this much of amount and the check is given for the loss of
You reduce it, but
and
right.
she has, I think she has given a launched a complaint in the labor department because we received the data.
That's what I said.
Most probably because order because
That's what I said. So, you know, payment is being made, it is made, payment is given for the work done. For the work done, right? Salary or wages are paid for work done. She has not done any contribution. From the sympathetic ground, as you know, she doesn't have any source of income, the company has paid something like, salary.
But sir, there is one law saying that we should pay for the amount within 2 weeks, 2 weeks within the month or something. We have to pay or something like that.
No, right? You will see it later, right? You will see it later.
So to avoid that situation,
Salary should
what
be
if
paid something to some level. I have to
Salary should be paid.
like within 2 weeks of the injury,
Yes.
something like that. I don't remember. There's something.
Let's see later, right? But you have to look at, you have to go and as an exercise, right? Get and the 2022 Act, right? Both and compare, right? Find out where is the, any, exceptions, or any provision to pay the salary, pay the salary. You know, the problem is in labor laws, deduction can be made only for the loss of damage, or I mean, uh, any, you know, right, intentionally done any what do you call damage or loss to the company.
but in this case, can the employer got a letter from the employee saying that
Yes,
yeah,
yes.
we will
We can't backdate and take.
This is an, in future, if such thing happens, okay, if she, says no, I don't have any means of, the income, so get in writing, okay, right? You will get the insurance payment, right? Give the consent to reduce the amount what the company pay. Get it? Otherwise, the person will go to labor department or LT, sorry, or the workman compensation. Then problem. So therefore, I think for my, view is better to give everything. Otherwise, you will lose more than 130,000 what you said in the case. For lawyers and harassment here, going here and there, coming to labor department or the workman compensation and hiring lawyers, everything. How much you have to pay? At least for one time a year, at least 25,000, 30,000 has to be paid for a you know for a
We have to do transport also.
transport also, right? Even the reputed lawyer will not appear for that amount. I know that because the lawyers from the Employers Federation of Ceylon, when they appear, charge is very high. I don't know whether the person is getting that amount, but charge is very high, very high. So better to pay. Is my advice, right? And this is, learn a lesson. Future, don't do it. Do that. Yes, if I lost on sympathetic ground, yes, we can do something, but not forever. We don't know. People also, the company may have, sympathy, but the worker, mostly, right? Most of workers, they don't have, that kind of sympathy. They don't respect.
After recovery, he has now approved the 60% from that amount.
So, right. So, in the case of workmen who are right masters of registered ships, oh, this one is not applicable actually right now. However, persons working as members of the armed force of Sri Lanka, other than those persons employed in civilian cap- capacity in those forces, army, those who are working in civilian capacity in army headquarters or clerical staff, they are covered, but not uniformed person, right? They are not covered, not included under this ordinance. Payment of compensation. The employer is liable to pay compensation for the workers who are injured in the course of their employment. Oh, ah, while coming from their place of residence to workplace, or while returning back to their place of residence from the workplace. Amendments Act number 10 of 2022. Previously, it was only in the course of their employment. Now, while coming from their workplace or residence to workplace, place of residence to workplace, or while returning back to their place, right, of residence from the workplace. This is the one I'm giving you an assignment, right? Discussion, right? So tell us whether it is okay or not. How do you prove it, right? Say for example, I'm working and going for my residence. While going, I get down from the bus, somewhere the wine stores is there, right? I drink and met with an accident. Is the employer liable? Is the employer liable? But according to new act, yes. Is it? So there are argument.
The company can make SOP or something for the distance and the time that the employee gets to reach the house or the residence.
You can't violate what law says. Law doesn't say the distance.
But under the influence of liquor, always it's argued.
How do you prove it?
That can be done even if he is met with an accident under the influence of liquor. Anyway, it's recorded. Right?
Yes, if she is, the person is, admitted to hospital,
Yeah, obviously.
right? Yes, right.
Otherwise, you can't prove. I mean, even the employee.
It's up to you, right? I will give an, what do you call, yeah.
Unfair.
So it's tell us, it's maybe group work, right? So the or contract and occupational disease, right? Personal injury by an accident, right? Contracts and occupational disease. Contracts any disease due to the nature of his employment. Compensation paid to dependents of any deceased workman, right? Or workman who dies as a result of any accident or occupational disease. And then the compensation to employees who get disabled as a result of an accident arising out of an in the course of his employment. So these are payment of compensation. The When can a workman claim compensation? If any worker contracts a disease or accident that could be reasonably attributed to the types of work she is doing while employed in any process or contracts an occupational disease as described in schedule 3. If you look at the schedule 3, it has been described, right? Schedule 3, such as, right, the infection, right, poisoning by, this is occupational disease, right? And by lead, uh, these are, please schedules, you have to look at schedule 3, right? The If you go to the ordinance, you will see the schedule 3. Schedule 3 talks about disease. And the original ordinance, is anyone else entitled to claim workers' compensation? The ordinance also provides for compensation to be paid to the dependents, to the dependents of the worker in the event of his or her demise as a result of work-related accident or occupational disease. If the person dies, like EPF, gratuity, the same thing, the same way, the compensation to be paid to the dependent. Who are the dependent?
Wife,
Wife and children. Wife and children first.
yeah,
Wife, how much she get? 50%. And then another 50% goes to children. If children are not there, parents. That 50% goes to parents, not to wife. Because of the, how do you call it? Police.
equity.
Yeah, equity and it's kind of a property law. Property. As per the property law. Property law is over there. If owner dies the land, right, then 50% goes to wife. Another 50% goes to okay. The same thing. Property law applies, when it comes to labor law. If there is, something to be divided, it could be done, should be done as per the property law in the land.
So someone unmarried,
Good question. Unmarried, there is no wife. Then for
if the parents are also unmarried,
Siblings.
then
Yes.
otherwise, no one is there. Then it goes to
State.
no.
State.
state. It goes to state.
So according to that, the document in LCA is here.
Documenting.
EPF is the liability or the provide the dependence.
Mhm.
According to that, also can be
I'm not getting you right. EPF. If EPF
I think
also.
she is referring to the beneficiary.
Beneficiary.
not in the B card, but there's another document.
Yes.
So according to that document, can we take
Right. It's a H, right? Form H. Nominee. Right? Nominee. Form H. ABH. Right? Oh, now it's a nominee. Right? Say, EPF, I told you, EPF, right. I told you, before you marry, you can nominate any person. I gave this example. I was in the private sector previously before I entered the, the administrative service in the country. So then I nominated my mother. But it will be automatically cancelled once you get married. You don't need to, inform. What you need is the marriage certificate. That is it. Automatically cancelled. But if you nominate someone after marriage, then spouse does not have any benefit. After after marriage, I have experience, right? I told you in the goal, right? So she was arguing with me. I said, no, it's no. Once, after your marriage, you nominate, you do it intentionally. Intentionally. එහෙම කරන ඒවා තියෙනවා. දන්නවද? ලොකු දෙපළක් big money තියන අය සමහර අය ඉන්නවා. sorry to say, I'm not, the blaming to anyone. We have experience. Some, the cunning ladies, Malari Kerala, Dalidagan and Leogan. සමහරවිට අහිංසක ළමයි දරුවෝ ඉන්නවා මොන්සරි ජීවත් වෙන්න විදියක් නැහැ ඒක තියෙනවා. So we have experience how it is. What to do? හොරට බැඳලා සමහර වෙලාවට. So those are happening. EPA once you after marriage, if you nominate someone, it's intention, but still, as per the this EPA Act, you can't do anything, but you have to consult a lawyer whether there is a possibility to go for high court and get some some other way of manipulating. Say we don't know that the person might have been manipulated by some other one and try to get the benefit. So you have to consult the lawyer. But as per the labor law, no. Below, no, there is no provision. Okay, right. Now, the ordinance also provides for the compensation to be paid to dependents of the worker in the event of death. This is possible. Now, just 1 second. Yeah. What is the amount of compensation that can be expected? What is the amount? Part 3 of this ordinance addresses the compensation payable in detail, right? You refer to part 3, very detailed provisions are there. The amount of compensation payable for injuries, right, sustained to a worker is listed in the relevant schedule under this ordinance. In this case, Schedule 1 and Schedule 4 are very important. You will see it later, Schedule 1 and Schedule 4. Right? Schedule 1 addresses payment details disablement. Again, how much you have to pay the disablement? 100%? 80%? I mean, loss of income, right? The loss of capacity. 100%? 100%? Or 80%? 70%? 10%? The loss of capacity, earning capacity. That is Schedule 3. Okay? And the Schedule 4 is the payment, compensation. So I will let you know later, right? Compensation will be computed proportionately with the loss of earning capacity, right? With the loss of earning capacity. Actually, Schedule 1, the companies, they are not, they don't need to look at Schedule 1. Schedule 4, very clear, how much you have to pay. Schedule 4 has, the provisions, how much you have to pay. Right. And then, capacity. In the event multiple injuries are caused by the same accident, the amount of compensation will be an aggregate amount, but it will not exceed the amount payable if payment total disablement had been the result. Schedule 4 addresses instances where death results. Death. Right. Schedule 1 is non-fatal. Right. How to pay for non-fatal accidents. Non-fatal means, there is no death, right? Partial disablement. Then how much it has to be paid, right? But Schedule 4 talks about payment in case of death. In case of death. It also addresses compensation for payment, total disablement as a result of the injuries sustained. The maximum payable is 2 million in the case of death or permanent disablement. Schedule 3 talks about, from the amount, how much you have to pay. 80%, because the person has not died alive, but lost the, earning capacity. Okay, well, now they're asking for you to have a cup of tea. මොනවද දෙන්නේ ප්ලේන් තියද්ද? බඩේ එකක්වත් දෙන්නේ නැද්ද? බඩේ එකක්වත් මොකද්ද ඔයගොල්ලෝ මේ මේක මගේ ප්‍රොපගැන්ඩා එකක් කියලා හිතන්න එපා. So I don't know, you might have seen in Facebook and some other, we are conducting kind of a 1-day workshop, right? Have you heard about Brain HR? Brain, you have this poster. Brain HR, we are working with them. Sanyam is a quite good guy in the corporate sector, right? Well, yeah, but he has a separate institute called Brain HR, right? Myself and the chief legal officer of the labor department, retired man, we are conducting kind of a 1-day workshop. So we are not targeting individual, the persons. We are targeting the company. Right? Company can send 1 or 2 HR people. First one is on 20th of. I will show you later. That numbers, it's not individual, right? 18,500 something like that per day. Only 1 day, right? On termination, right? How to terminate people, and related problems. We are not targeting individual people like you. We are targeting the company, right? Company may send, because companies are sending people for training. We're targeting now. We have around 30 confirmed, 30 participants. It's on 20th. Likewise, we will be having series of workshops, right? One for termination, one for terms and conditions. It's kind of a 1 day, right? I will share with you, but I can't share it,
Anything that will be covered, we are not covering it.
because it's like this. When it comes to termination, right? I don't know termination, who has done the termination.
It will be on the industrial dispute.
Yeah, uh, because those who are learning the certificate course or diploma, they will learn everything. But most of the companies we have understood, we have observed, they don't have HR people, they don't have much knowledge, right? One thing I realized that I was supposed to it's a consultation uh, for automobile company. I had a consultation. I realized that they have done blunders. The workers, not the office people, but all other workers are covered in the automobile industry by uh, engineering trade wages board. Engineering trade wages board. But and all other, the benefits when it comes to leave, all they are the granted workers have been granted leave as per the Sopan Office Employees Act. can't imagine how much the mandates lost to the company. They don't know. Casual, annual, and what do you call this, mercantile, all. But they are entitled only for 14 days of annual leave under the engineering trade wages code. So okay, go ahead and have your tea and come back.
So can I ask one question from you?
This is my first class actually.
Okay.
I'm Subhash
Okay, nice to meet you.
and I'm doing my finals at tennis.
Ah, okay. Milanga, Milanga, ඔබ බිසිද? උවදින් එළියද නැත්නම් මගද? ආ එහෙමද? Okay, okay. And there's one second, one second.
Okay.
නෑ මට පොඩි මේ දුරකථන ගන්න ගත්තේ. Kuapi mea. Good question. I double checked. Right. Puluang. There is no written, right? Something there is no written in law, but uh, no one can have double benefits. Your question, right? Uh, Very good question you raised, right? Uh, I double check it, and because this ordinance, I have substantial knowledge on other what do you call labor laws. This one is not coming under the labor department, no. So therefore, I also, I mean, not thorough knowledge, but I have thorough knowledge with regard to others. So I double check. I check with my daughter, right? Because she is attending compensation, LT, everywhere. There is no written law, right, allowing employer to deduct. But the fundamental principle is you can't have double benefits for one incident, right? Double benefit. So therefore, until, because it depends, you have to look at the schedule, right? Schedule says how many times in 2 weeks time you have to pay, you know in 2 weeks, it's fortnightly payment, you have to pay basic, right? Half a month's salary, it says half a month's salary, 2 weeks, it means 2 times means basic, only basic salary has to be paid until when? Until the doctor or someone has said, you know kind of the proof from the medical or doctor or whatever it is. So until this, up to this level, this date, she is not supposed to work or something like that. Until then you have to pay, and you can deduct what you have paid from the lump sum amount according to the law. Okay, but definitely she or he, this is the practical situation, right? She will approach to the commissioner compensation, not labor department. Labor department does not have any legal right to intervene into this matter, because this piece of legislation does not come under the under the purview of the commissioner general of labor. Whether she goes to if she goes to labor department, and if the company will be asked to summon genuine, very nicely, you have to mention, you have to write to the labor commissioner general or labor department that you don't have jurisdiction to intervene into this matter, right? Because labor department does not have jurisdiction to intervene into compensation, because it's not coming under the purview of the Department of Labor. But the person can approach to the compensation commission. So workman compensation commission. Then you have to prove that. So we have paid this much, this amount. So you have right. She will definitely grant. The commissioner definitely has to, because you can't have benefits, 2 times benefit for one incident. That is the argument. But it has not been written in this piece of legislation. That is argument. Okay. Yes. In case, in case she or he complain to the commissioner workman compensation, then you have to prove it. We have deducted because we have paid this amount. So therefore, you have legitimate company has a legitimate right to reduce it. So because practically, it has not been written in law, but they, the person approached to complain to the commissioner workman compensation. My daughter told me that there are plenty of the cases that the commissioner has granted to reduce amount in case of complaint, right? Otherwise, you can reduce it. Okay, got it? Right. Okay.
Where is that office? Compensation.
Here in this building, 17th floor or 15th floor. No, not with this building, the other one, 15th floor. Right? You got it now? It's very clear, huh? Very clear. But how many months it has to be paid? You have to look at the schedule, and we don't know. Say is a 1 day or 2 day or 3 day, and at the same time, there is another point, right? What you can do is you can uh, say if the person has earned leave, if the person has earned and disease, the affected person has uh, leave, earned leave to be used, then you can deduct from that the leave, right? While paying is a kind of a leave is you can grant leave, not no pay leave. You can pay and grant leave. Okay, are you getting my point? Right? Reduce, but then sorry. සෑවෙලා නැහැ මෙච්චර වෙලා
කලින් සෑවෙලා තිබ්බේ මොකක් කරේලා ආයෙ සෑවෙලා
right. So then this is a critical question, right? Not in written law, you have to argue. So in case if you like say grant her to take earn leave and you pay, then undeduct. That is better, right? The amount that you have, it says the Ordinance Act says in 2 weeks time you have to pay the basic, right? Half a month salary in 2 weeks means basic salary per month, right? Monthly salary. Okay, got it? Right. And in case, I'm repeating, if you receive a notice from the Labor Department, don't come, don't go to the Labor Department. Right? Ask the Commissioner General, sir, what is the I mean jurisdiction that you have, right, in order to interfere into compensation matters. That is it. Because the Labor Department has no jurisdiction. It is implemented by a separate institution called Workmen, Office of the Workmen Compensation. Okay.
Have you got the letter from the Commission of Labor or Commission of the Workers? No, because chances are that if it comes to Labor Department would know that it is not coming under their jurisdiction and they will.
But I'm telling you, those guys, the labor officers are handling this one, no, right? Most of them, they don't have sufficient knowledge. The recently recruited people, right? They don't have, right? I know that because sometimes, they ask, they don't have jurisdiction. but they ask for someone to I mean the employer sometimes. There are cases I have noticed. කුමාරපෙන් බැනලා තියෙනවා සමහරවිට. මගේ කාලේ. So oh, let me tell you one classic example. Without a union, the Labor Department filed a case with the magistrate court on unfair labor practices for a reputed company in the country. They are exporting everything, exporting to US market, mainly UK, right? They lost 20% of their demand, the quota, due to this unfair labor practice case. But there is no unfair labor practice. On the behest of the political, person, case was filed. So imagine loss to the country and 20% deduction, 20% reduce from his market share. It's lost one fifth, one fifth. So labor department, the law now. If it comes under anything comes under the purview of the labor department, yes, you have to. And there are 14 legislations, right? That 14 legislation. Out of two is ETF Act, they don't have jurisdiction. Compensation ordinance, labor department does not have any jurisdiction. The legal power to intervene into that matter. So know that, right? Very nicely. Otherwise, I have done some of these things, for the companies, not for, there is no pre-lunch, right? I do consultancy otherwise, being the Commissioner General of Labor, yes, it is my duty, but not now. Okay, anyway. Right. So, what is the process for the payment, right? Distribution and recovery of compensation. So, look, under Section 11(1), the ordinance stipulates that no payment of compensation in respect of a worker whose injury has resulted in death, and no payment of a lump sum as compensation to workman or person under legal disability age, right, of 18 years, right, can be made directly by the employer to the dependents other than by depositing the sum with the commissioner, right? Depositing with the commissioner. Again, the heart at Aduna Mogadakaranoni, dependent life. Everything, it is under 18. Say what it says, no payment of compensation in respect of a worker whose injury has resulted in death, and no payment of a lump sum as compensation to a workman or person under legal disability age 18 and above can be made directly by the employer to the dependents other than by depositing the sum with the commission the employer has. If the dependents are less than age of 18, then what will happen? You can't pay for them. You have to deposit that money with the commission because it's not legal age. Below 18 years, they are, if the amount, say for example, spouse is there, 50% goes to spouse, can directly pay, and another 50% goes to children. There are two children, say they are under 18 years, then that amount has to be deposited with the commission. The company is not supposed to pay, is not supposed to pay directly to spouse or the dependent. But if they are above 18, yes, right?
Why is the word woman highlighted here? They could have just said any person under legal disability, right?
Yes, yes, because some not only woman, spouse, right? Spouse,
Or any person.
any person,
Yeah.
any person, any person. Any payment made directly to the dependents will not be deemed to be a payment of compensation. What does it mean? Any payments made directly to the dependents will not be deemed to be a payment of compensation. Why is it?
If it's an injury, it will come under compensation. If it's a death,
Yes, right. And upon deposit of the compensation sum by the commissioner will deduct the actual cost of the workers' funeral expenses. That means if the employer has granted something, it means this is the only place we can identify, indirectly say this says only for funeral. But if something has been paid, we can argue, yes, you can't have both benefits from compensation or insurance and also salary, right? Okay, right. uh, and then as per the section 16(1), all proceedings for the recovery of compensation can be brought before the commission, after notice of accident has been given in the manner detailed in the ordinance. It means that uh, it is the duty of the employer to inform if accident taken place. It is the duty of the employer to inform the commissioner workman compensation. This is the duty. And if you have, you know, the person has been injured, it can also, but this is the amount, right, we are going to pay. Whatever the details can be submitted to the commissioner work. Then the case will be heard if the person complains to the commission. Okay? It is the duty of the employer to pay compensation if something happens. And inform the commissioner saying that this has been taken place, but you have to inform the accident definitely, right? This accident has been taken place, so this is the compensation, this is the medical report and everything. The compensation, this is the amount that the person will be compensated. Has to be informed. And next, the all proceedings, right? Second, such notice must be given as soon as is practicable and before the worker has voluntarily left the employment in which he was employed. Right? Such notice must be given as soon as, right? uh, uh, is practicable. ප්‍රැක්ටිකල් විදියට දෙන්න පුළුවන් උපරිමයෙන් ඒ කියන්නේ උපරිම දවසෙන් ඒක දෙන්න ඕනේ. Before the worker has voluntarily left the employment in which he was employed. And section 16(1) says again, the claim for compensation must be made within 2 years of the occurrence of the accident, and in the case of death, within 2 years from the date of death. This is the original one. Right? Later, some changes have been made. You will see it later. Right? This one from principal ordinance. Principal. Right? And in the case of contracting a disease as a result of an accident, then the accident will deem to have happened on the first day from which the worker was continuously absent from the work. Look at, in the case of contracting a disease, as a result of an accident, then the accident will be deemed to have happened on the first day. කියන්නේ අපි දන්නේ නැහැ. හැබැයි වැඩ දෙන්නේ නැති පළවෙනි දවසේ. Right? Deemed to have happened on the first day. First day. From which the worker was continuously absent from the work. එන්නේ නැහැ. එතකොට මේකේ first day එකේ ඉඳලා තමයි එක ගණන් ගන්න ඕන. Okay? Right. Now, Section 16(2) states that the commissioner may admit and decide upon a claim to compensation in the event notice required by the ordinance has not been given, or if the claim was not instituted within the stipulated time frame, if he is satisfied that the failure to give notice or institute a claim was due to sufficient cause. What does it mean? The commissioner may admit and decide upon a claim to compensation in the event notice required by the ordinance has not been given. Notice not been given. Oh, if the claim was not instituted within the stipulated time frame, then it is decided by whom? The commissioner will admit and decide. The power has been vested with the commissioner workman compensation.
Here the notice refers to the notice by the employer.
Employer.
Employee doesn't have any.
No, employer. It has to be, as per the factory's ordinance. If it comes under the factory, right? Here, this is not, under the workman compensation. It has not been, the defined to any particular workplace. This may be, industrial undertaking or soap and office, whatever it is, right? But under the factory's ordinance, if something accident taken place, now this is accident, because this, it has to be proved, no, this is accident taken place. But when it comes to food poison, also, definitely notice the within 24 hours, if I'm not mistaken, right? Under the factory's ordinance, immediately it has to be reported to the district factory inspecting engineer working under the Department of Labor. District factory, you have to, the first, immediately, you have to inform, the employer has to inform the district factory inspecting engineer. There are 10 district factory inspecting engineering office under the Department of Labor. The nearest one, it has to be reported. Then that report goes to commissioner compensation as well. If the employer has not report to the workman compensation, automatically, it's the duty of the labor department to inform the commissioner. Then commissioner workman compensation will interfere.
So if the meals are provided by the company or the factory.
No, don't misunderstand, right? Occupational accident and diseases, both, right, has to be reported. Say, for example, occupational diseases, right? So, you have lung problem, right? Due to long time working in asbestos company, it has to be proved. No,
That's okay. I'm talking about if it's a food
it's a
poisoning.
food poison.
Yeah.
Food poison, that is also disease.
But one company can argue that we didn't provide any food for the employees.
It's later now.
Oh,
Argument can take place later, but the duty of the employer, if something happened, ventilation, right? We have, you might have heard this, without the proper ventilation, significant number of women workers have been affected, like Usmagan Baru, right? So those things must be reported immediately, not to the workman compensation, but to the labor department. Labor department will take action. You have to understand this. Labor department will take action against the employer for employing people, employing them without proper safety and health, without proper safety and health environment. So labor department will take action against the employer for not providing proper working environment. But the compensation, labor department cannot impose the employer to pay compensation. It should go to the workman compensation office. You understand my point, right? So if something has happened, better to inform both. Labor department must compensation if the person has been insured and the insurance, from the insurance, the person has been compensated. If it is, legal as per the, the legal provisions, you don't need to inform the workman compensation because you have done your part. The employer has done as per the legal provisions. But under the factories ordinance, incident must be reported to labor department. The factory inspecting engineer. Factory labor department will take legal action against the employer for not providing proper working environment. Employing people without proper safety and health. But compensation part goes to the workman compensation. I'm repeating, if any employer has paid compensation as per the law within the legal provisions, then reporting to workman compensation is not required. Why? 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 Because the employer has done as per the compensation ordinance. Compensation has been paid as per the provisions of this ordinance. Okay. In case, but better to inform because otherwise, there is no requirement if you have done, everything, as per the legal provisions. But the worker may complain, affected or disease or contracted worker may report to the compensation commission. Then you have to go, cumbersome exercise. So therefore, better this incident has been taken place. So these are the people affected, and we have insured them, right? Insurance payment, right? We have paid this. Just inform to avoid unnecessary, involvement.
Anyway, they are supposed to maintain records.
Yes, they are supposed to maintain record. And it's definite. They are supposed to maintain record.
Sir,
Yes. Terminator. මේකට අවදාව වෙනත් ප්‍රශ්නයක් වහන්න. right? ඩොමිනේට් කරන්නේ ඉන්ජිනියර් නෑ.
එතකොට යාගේ ආර්ගියුමන්ට් එකක් වෙනවා ගවර්න්මන්ට් එකේ අපේ පළවෙනි ඉඳන් සර්විස් ඉන්ක්‍රීස් කරලා 7,000 වුණා. ඒක වාස්තු 27
පොඩෙන් කොහෙද
දැන් ගවර්න්මන්ට් නෑ තාම කරනවා කියන්නේ කිව්වනේ
නෑ පොඩේ කරනවා කියලා කිව්වා. හොඳට මතක තියාගන්න. ඒක ප්‍රයිවට් සෙක්ටර් එකේ අයගේ ප්‍රයිවට් සෙක්ටර් අයගේ පඩි වැඩි කරන්න පුළුවන් ක්‍රම දෙකයි. ප්‍රයිවට් සෙක්ටර් එකේ පඩි වැඩි කරන්න පුළුවන් ක්‍රම දෙකයි. එකක් තමයි මිනිමම් වේජ් ඇක්ට් එකට ඇමෙන්ඩ්මන්ට් එකක් ගෙනල්ලා දැන් 17500යිනේ තියෙන්නේ. ඔයාලා 21000 හිතේ තියාගෙන මිනිමම් වේජ් නෙමෙයි යා. Minimum wage 17,500 and on top of that 2 bravas. Brava කියන්නේ minimum wage නෙමෙයි යා. That is a mistake, you know. So minimum wage 17,500. And there on top of that there are 2 bravas, right? 1,000 and 2,500. Altogether, you know, 21,000. That is not basic salary. That is not minimum salary. That is your basic. Right? Minimum salary as per the minimum wage act 17,500. Okay, amend කරලා මොකද කරන්න පුළුවන්? So it can be, you know, increase up to 25,000 whatever, right? Abolition brava ඔක්කොම එකතු කරලා කරන්න පුළුවන්. The second way is bringing another brava, budget relief allowance of workers act. තව brava එකක් ගේනවා එනද වැඩි කරන්න. ඒක නීතියක් බවට පත් වෙන තෙක් right? ඒක ඒ 50ත් ඇමෙන්ඩ් කරලා පාර්ලිමේන්තුවෙන් ඇමෙන්ඩ් කරලා නීතියක් බවට පත් වෙන තෙක් අර තියෙන එක තමයි බලන්නේ. right? මේක තමයි බලන්නේ. වචන වලට කට වචනේ ආණ්ඩුවේ පුළුවන් මොකද කරන්නේ? රාජ්‍ය පරිපාලන චක්‍රයේ ඉඳින් පඩි වැඩි කරන්න පුළුවන්.
ආර්ගියුමන්ට් එක ආවා.
ඔව්. ඔව්. දැන් මෙහෙම තත්ත්වයක දැන් මේ දෙවියෝකියා අක්ෂරන්නේ එයාගේ ඉන්කැපැසිටේෂන් right කියන්නේ කැපැසිටි එකක් නැහැ ඉන්කැපැසිටි එහෙම නැතු ඒ කියන්නේ ඉන්කැපැසිටේෂන් එක උනේ ආයතනයේ දිගින් වැඩ කිරීමෙන් හෝ ඇක්සිඩන්ට් එකක් වෙලාද එහෙම නැත්නම් වෙන හේතුවක් පැරලයිස් වුණේ වැඩ කරලාද paralyzed වීම can be attributed to work. paralyzed වුණේ මම වැඩ කරපු නින්දායි කියලා එකට සම්බන්ධ කරන්න පුළුවන්. දැන් ඉන්න ප්‍රශ්නේ තමයි හරිද? දැන් මේක වැටෙන්නේ නැහැ workman compensation. වැටෙන්නේ නැහැ. workman compensation කියන්නේ මොකද? In the course of their employment, right? හැබැයි ඊට අමතරව කියනවා right while you know traveling from workplace to residence and coming from residence to workplace, right? ඒ අතරතුර accident එකක් or disease. So your case paralyzed උන එක attribute කරන්න බෑ. ඒක link කරන්න බෑ. ඔබ මිනිස්සුන්ට කියන්න බෑ මම paralyzed උනේ ඔබලගේ ළඟ වැඩ කරපු නිසා කියලා. පුළුවන්ද? මෙහෙමයි. ඔප්පු කරන්න එක හරි අමාරුයි. It's very difficult to prove. ඒ ඔක්කොම අදාළයි කියමුකෝ. දැන් compensation එක ගෙවන්නේ partial disable කියන්නේ incapacitation කියන එක කියන්නේ 100% incapacitation නම් ඒ කියන්නේ මේ accident එකක් වෙලා earning capacity එක 100% does not equal to death නේ. equal to death. ඒකට මිලියන දෙකයිනේ maximum. මිලියන දෙක ගෙවුවාම දැන් කතන්දරේ කියන්නේ it's very you know that is how you learn. මේ මේක පෙරලගෙන මොකද්ද? 52 ගත්තා 52 බැලුවාම ඒ කරුණු අවබෝධ කරගන්න පුළුවන්. ටික මම මේ කියන කරුණු ටික so you go download the ordinance and the new act as well, then read it, you can understand. But when it comes to practical situation, this is very interesting case. Tell me that millions they are given. හරි එහෙම මම කියන්නේ ඒක වැටෙන්නේ ඔයාලට යාව ප්‍රශ්න කියන්න බෑ. ඕචුනේට්ලි මේකට දාලා යවන්න පුළුවන් නම් යවන්න. මොකද ප්‍රැක්ටිකල් වලම තියෙන පාස්ට් ස්ටේට්මන්ට් කියලා මේක වැඩ ගන්න බෑ කියන එක. ඒක අපිට පුළුවන් මේ සේවකයාට නෑ ඒක මෙහෙම වෙන්නේ බෑ. සම්දියක් දෙන්න ඔයාලා ඔය මේ පන්නත හරියට කියවන්න බෑ. මේ පන්නත එයා ගිහිල්ලා ආල්ගුමන්ට් එකක් දැම්මොත් එහෙම හරිද? මේක වෙන පැත්තක් තියෙනවා. හරිද? ඒක මොකද කියන්නේ වෙන පැත්තක් තියෙනවා. මේක කොයි වෙලාවකත් ඕකේ ඇටිටියුඩ් කරන්න බෑ. not attitude cannot be attributed to work. paralyzed වෙන්නේ නැත්නම් වෙන මොකක් හරි හිතුවා. මේක පාරම ඉන්නේ paralyzed වෙනවද වැඩ කරලා ඉilla මොනවද යා කරපු දේවල්. ඒක පොඩි ආගියුමන්ට් එකක් තියෙනවා. හරිද? පොඩි ආගියුමන්ට් එකක් තියෙනවා paralyzed වෙන්න පුළුවන්. ඕචුනේ මේකෙන් දීලා යවන්න හැබැයි අර 27000ට ඒක 25000කට හදන්න බෑ. ඒක හදන්න බෑ. කියන්නේ ඕකේ කැපැසිටේෂන්. කියන්නේ ඔය paralyzed කියන අනිත් පැත්තේ ආගියුමන්ට් එක තමයි. මේකට වැටෙන්නේ නැහැ. හරි මේ පනතට cannot come under the workman compensation ordinance. එතකොට අයින් කරන්න බෑ. because ඒක මේකට වැටෙන්නේ නැත්නම් incapacitation is ඒක එනකොට කියන්න පුළුවන් මෙහෙම misconduct sorry මොනවාද මේ so termination එකට යනවා. ඒවකට ගියොත් මොකද කෙනෙක් argue කරොත් is paralyzed cannot be attributed to work. So therefore compensation, right? I'm not supposed to leave the place, or the employer cannot terminate me under the compensation ordinance. Argument එකක් එන්න පුළුවන්. හරිද? එහෙමයි ඒක argue කරන්න පුළුවන් machine එකේ වැඩ කරලා so for long time 30 years, so maybe something happened, right? So it's an argument. Okay, the company has accepted. Then 2 million, right? 2 million. Company is ready to pay 2 million as well. Maximum 2 million. Then 2 million or less than that. අඩු වෙනද මිලියන් දෙකම ගෙවනවා. අඩු කරා. කියන්නේ පාසල් 1.8 අන්තිමට උපදේශෙමයි. මිලියන් දෙක දීලා 1.8 ලක්ෂ දෙකයි. ලක්ෂ දෙකම නැත්තම් ඕක වෙන පැත්තකට ගිහලා ටර්මිනේෂන් ගියොත් එහෙම අස් කරන්න බෑ. අස් කරාම ඕ වන්දි ගෙවන්න ඕන. ගණන් හදලා බලන්න. ඒකෙත් හැබැයි 2.5 billion maximum යන්නේ. Maximum 2.5 million. So my, advice to the company is, if just the company has agreed to pay 1.8 million, so දැන් අරගොල්ලෝ මම පේරන්ට් යුනියන් ඔය ආගියුමන්ට් එක වැඩක් නැහැ. ඒක තමයි ආණ්ඩුව ප්‍රකාශයක් කළා තියෙන්නේ. ප්‍රකාශයක් කරපු පළියට මේකට එන්න බෑ. හැබැයි මම එහෙම කියන්නේ. ඒක වෙන පැත්තකට ගියොත්. කවුරු හරි මෙතන වෙන කවුරු ගිහිල්ලා කියන්න මේව නැහැනේ. මේ වෙන ලුයි කවුරු හරි කෙනෙක් ඒව කරලා සම්බන්ධ නැහැ. ඔයා යන්න එපා. ඒක අරන් අවසන් වෙනවා. ඒක කම්පැනි එක අස්කරන්නත් ඕනේ. හරිද? නම් තීන්දුව තියෙනවා. ඉන්කැපැසිටේෂන් කියන්නේ මිස්කන්ඩක්ට් වලට දාන්න බෑ. right? ශ්‍රේෂ්ඨාධිකරණ Supreme Court judgments are there. මොකද ඔය වල තිබුණාද මේක මොනවාද? මේවා මොනවාද? මොඩියුල් එකක් තියනවාද? disciplinary proceeding. disciplinary procedure එකට කලින් කරන්න ඕනේ discipline කියන්නේ මොකක්ද? කියන්නේ වැටෙන්නේ මොනවද? discipline වලට වැටෙන්නේ misconduct එකක්. right? misconduct මොනවද කියලා ලියලා තියෙනවද? ලංකාවේ නැහැ. එහෙනම් කොහොමද ඒවා ගන්න? case law. case law. මගේ ළඟ මම හිතන්නේ slides 100 ගානක තියෙන ඕකේ presentation එක. misconduct and disciplinary procedure and the punishment. 150 का 112 විතර වගේ මම මතකයි. ඒ කියන්නේ එක්කම තියෙන නඩු තියෙනවා. right? එතකොට කෙනෙක් අරයා වෙන කෙනෙකුට ගිහිල්ලා කවුරු හරි කෙනෙක් අල්ලගෙන අපි කියන ලේබර් ඩිපාර්ට්මන්ට් අනිවාර්යයෙන්ම ඕකේ. ඉතින් ඉන්නවා. අයින් කරන්න බෑ. අයින් කරන්න ලීගලි මොකද කරන්න ඕනේ? ඕක කරන්නේ ඔයාලා එයා කියයි මම අර මිනිස්සුන්ට කිව්වොත් එහෙම මේකට ඇටිබියුට් නැහැ කියලා කිව්වොත් ඒක ආගියු කරලා අයින් කරන්න බෑ. අයින් කරන්න නම් මොකද කරන්න ඕනේ? කොමසාරි ජෙනරාල් ගාවට ගිහිල්ලා අවසර ගන්න ඕනේ. මේ මිනිහගෙන් නැත්නම් ලිඛිත අවසරය ගන්න ඕනේ. නැත්නම් ඒක දෙන්නෙත් නැහැ. එතකොට කමිෂනර් ජෙනරල් ගාවට ගිහිල්ලා මාස 6කට වැඩි යනවා කමිෂනර් ජෙනරල්ගේ ඕඩර් එක දෙන්න. හරිද? මාස 6ක් කරාම පඩි ගෙවන්නත් ඕනේ. better to pay 2 million. Let him go. මේක මගේ ඇඩ්වයිස් එක. හරි? ඉතින් කියන්න. ඔව්. ඔව් කියන එක තමයි. ඔව්. ඔව්. අවුරුදු දෙකකින් collective agreement එක ගන්න mostly 2 years or 3 years නේ. ඔව්.
එතකොට ගවර්න්මන්ට් එකෙන් කරන salary increase එක පාවල් වල කන්ද මිනිමම් එනවාට collective agreement කියන කම්පැනි වල.
තමයි. ඒ බ්‍රාව එකේම කියනවා බ්‍රාව ගෙනාවා minimum wage ගෙනාවා collective agreement එකේ applicable වෙන්නේ කොහොමද කියලා තියෙනවා. right? බලන්න දැන් බ්‍රාව එක ගත්තත් collective agreement දැන් minimum wage act එක තියෙනවානේ. ඒක collective agreement වල එක තියෙනවා නම් ඒක exempt වෙනවා. හරිද? collective agreement එක නේ minimum එක නේ තියෙන්නේ. collective agreement එකේ ඊට වඩා provisions තියෙනවා නම් right workers cover එකේ තියෙනවා exemptions. workers covered by the collective agreement. exemptions. ඒ වගේ බ්‍රාව එක ගේනකොට කියනවා. කියන්න ඕන. ලෝ එකේ එහෙම ගේන්න නැතුව කියන්න බෑ. එහෙම බ්‍රාව එකක් අලුතෙන් ගෙනව දැන් අලුත් මේව බ්‍රාව එක බලන්නකො. budgetary relief allowance of workers act එකේ right ඒක applicable හැබැයි minimum wage එක applicable නැහැ collective agreement කියන තැන right ඒ වගේ බ්‍රාව එකක් දෙනවා නම් budgetary relief allowance of workers act එකක් enact කරනකොටම ඒක බලපාන්නේ මොන කැටගරි වලටද කියලා කියනවා කියන්නේ minimum wage එක දෙනවනේ ඒක දැන් මෙහෙම හිතන්න collective agreement එකක් තියෙනවා collective agreement එකේ සමහර අයගේ වැටු ඒ අවස්ථාව වෙනකොට දැන් ගාව ගමු 40000ට අඩුයි
දැන් එක්සැම්පල් එකක්
ඔව්
දැන් හිතන්න දැන් මේ කාර්යකාරය ගවර්න්මන්ට් එකේ කියන 27000 වල මුල්ම වේජ් එක වැඩි කරනවා
කියලා තියෙනවා
කියලා. බත් ඇක්ට් එකේ එනවා.
ඔව්
ඇක්ට් එක නම් හිතන්න මේ ඩෝන් ආස්තේ හරි උදාහරණයක් කියනවා.
ඔව්
මේක පස්සේ නෝදලා ප්ලෑන් කරනවා.
ඔව්
එතකොට එතනදී ඒකට කොට සේවකයන්ගේ පඩිය මිනිමම් වේජ් එක 28 අඩුවෙන් තමයි තියෙන්නේ ටැක්ස් එක ඇතුලේ.
ඔව්
එතකොට මේ පේරන්ට් වෙනින් කාර්යයක් කියනවා මේගොල්ලන් පඩිය ඉන්ක්‍රීස් කරන්න ඕනේ මොන සංස්ථාවකට වලට කියලා. බත් අපි බ්‍රාය කරන දුර ඒගොල්ලන්ට දැන් මම කොහොමද කලින් එකම දක්වන්නේ තමයි සයින් කරලා තියෙන්නේ. ඒක අපි ඒනකොට ඒගොල්ලන්ගේ තියෙන මිනිමම් වේජ් එක වැඩි කරනවා කලිස්ට් ඇග්‍රීමන්ට් එකේ සැලරි ඉන්ක්‍රීස් එකත් එක්ක. ඒක ඒනකම් මේ ඒගොල්ලන් අඩු මිනිමම් වේජ් එක අපි තියාගෙන යනවා. මොකද අපි සැලරි ඉන්ක්‍රීස් උදා 2000 වැඩිවත් කියනවා. ඒක කොහොමද කොහොමද මිනිමම් වේජ් වල අපිට ඒක කරපු අඩු වෙන කප්පින් සද්දක වැඩි වෙනවා. ඒක අරමුණු කරකන එහෙම කරන්න බෑ. ඒක සෙනෙකට අසාධාරණ ලක්ෂණයක් කියලා අපල අමුතු වෙනවා.
පේරන්ට් යුනියන්ගේ තර්කේ හරි. හේතුව තමයි ඉස්සෙල්ලා බලන්න ඕන බ්‍රාවෝ එකේ ගේනකොට කන්ඩිෂන්ස් තියෙනවා. එහෙම නැතුව එකපාරම අපිට කියන්න බෑ. දැන් සමහර වෙලාවල් වල තියෙනවා කියන්නේ යම්කිසි ආකාරයක වැටුප් වැඩිවීමක් සිදු කර ඇතනම් හරිද? ඒක කියන්නේ ඉන්ක්‍රිමන්ට් එක නෙමෙයි වැටුප් කර ඇතනම් එයා අඩු කරන්න අවසර දෙනවා බ්‍රාවෝ එකෙන්. අඩු කරලා ඉතුරු ටික ගෙවන්න අවසර දෙනවා. හරිද? ඒකට බලන්න ඕනේ එකේ කන්ඩිෂන්. හැබැයි ලෝ එකක් ගෙනාවට පස්සේ ඒක තමයි රටේ මිනිමම් ලෝ එක. හරිද? ලෝ එක වයලේට් කරන්න බෑ. ඒක අපිට බෑ. කලෙක්ටිව් ඇග්‍රීමන්ට් එකක් තිබුණයි කියලා. දැන් මෙහෙම හිතන්නකෝ. මිනිමම් වේජ් එක 17,500 වලට ඉන්ක්‍රීස් වෙනකොට දැන් ඉන්ක්‍රීස් වෙලා නේ වෙනකොට වේජස් බෝඩ් ගොඩකගේ සමහර ඒවායි මිනිමම් එක සිකියුරිටි ගත්තොත් 16,000 තිබුණා. වැඩි කරන්න ඕනේ. වැඩි කරන්න ඕනේ. මිනිමම් එකේ අඩු කරන්න බෑ. එහෙනම් කරන්න ඕනේ. දැන් මේකට කම්පැනි එකට තියෙනවා නම් දැන් මේක ගෙවන්නම වෙනවා. දෙකක් නෑ. එතකොට කම්පැනි එකට පුළුවන් මොනව කරන්නද? දැන් මේකෙන් අවශ්‍යයක් වෙනවා කියලා හිතන්නකෝ කම්පැනි එක. there may be a, cost to the company.
ස්ටාෆ් එකේ කෙනෙක් ඊළඟ අඩුවෙන් තමයි සර්විස් එක තියෙන්නේ. ඒකවල ස්ටාෆ් එකේ ඉතන ආගියු කරනවා. ස්ටාෆ් එකේ මොන ක්වොලිෆිකේෂන් එකම අය සර්වර් එකේ මෙච්චරයි. නම් ස්කිල් වර්ක් කරන එකේ නාමයට මෙච්චරයි.
එතකොට ස්ටාෆ් එක්ක නම් හව වෙන්නේ නැද්ද කලෙක්ටිව් ඇග්‍රීමන්ට් එකේ? එහෙනම් හොඳම දේ බං කියන්නේ. Company can refuse that. Collective agreement. පුළුවන් කමිෂන් ජෙනරල්ට දැනුම් දීලා අයින් වෙන්න පුළුවන්. හරි? මේක කරන්නේ නැහැ. එහෙනම් මේක මොකද කියන්නේ? රීනිගෝෂියේට්. හරි. මේක රීනිගෝෂියේට් කරනවා. මොකද මිනිමම් වේජ් එක මේක ආවට පස්සේ ආම 20,000 කරේ නැහැ. කරේ නැහැ. ඒක කරන්නේ නැහැ. කරනවා. කියන්නේ ඕගොල්ලෝ හොඳටම දන්නවා. ඡන්දෙන් පස්සේ කරනවා. මෙහෙමයි 20,000 කරොත් සාමාන්‍යයෙන් 20,000 ඕන තමයි සේව් කරන්නේ. නැතුව දුවන්න බෑ. ඉතින් සාමාන්‍යයෙන් 20,000 කියන්නේ ටේක් හෝම් එක 40වත් 40 ප්ලස් 50වත් ඇතින් පල්ලා කෙනෙක්ගේ. 20,000 කියන්නේ ටේක් හෝම් එකේ ඔය ගන්න කැප. but මට කියන්න තියෙන්නේ until law is enacted you are not company is not obliged. Where enact කරාට පස්සේ law cannot be violated. Law is a minimum. You can go up to sky. That is the law. You can't go beyond that. If there are discrepancies or discrimination, then you have to renegotiate with the trade union and include some clauses to the existing the collective agreement. So okay, right? Is it? Oh, Workmen here. Oh. if you have permission to employ right, at night, again, female and the female side, male side. Male side restrictions, man.
මම ටැක්ස් එකේ තියෙනවා 40 කිලෝමීටර් අඩු නම් half එකක් entitled වෙනවා කියන්නේ.
half එකක් entitled.
ඒක තරක කරා ඒ half එකේ එනවා හින්දා අපි අරගෙන බෑ කියලා.
මෙහෙමයි. ඔතෙන්දී බලපාන්නේ කම්කරු නීතිය නෙමෙයි ඉලෙක්ෂන් ලෝ එක. ඉලෙක්ෂන් ලෝ එකේ අනුව තමයි කම්කරු නීතිය යටතේ ඔක මූව් කරන්න බෑ. මෙහෙමයි. සේවකව වැඩ දෙන්න කැමති නම් يعني වැඩක් තියෙනවා නම් වැඩ දුන්නයි කියලා ඒකේ කම්කරු නීතියෙන් ওই ප්‍රශ්නේ ඇඩ්‍රස් කරන්න බෑ. ඒ කියන්නේ ඒගොල්ලෝ කියන්නේ ඉලෙක්ෂන් එක ආදරයට ඉවරයි. ඒකට half a day එකක් දෙන්න ඕන කියලාද කියන්නේ? මොකක්ද
ඒ
කියන්නේ?
කියන්නේ 40 කිලෝමීටර් අඩු නම් එයා half එකක් entitled
ඔව්. ඉතින් උදේ half day එකක් දුන්නා ඔය හරියට.
shift එක මේ උදේ එක දුවන්නේ නැහැ. ඒක දුවන්නේ night වල. ඒක hours වල පැත්තේ night shift එක තමයි පටන් ගන්න ලබන්නේ election එක හින්දා.
හරි. එතකොට දැන් උදේ shift එක දුවන්නේ නැහැ නේ. ඉතින් උදේ shift එක දුන්නාම half a day එකක් දෙන්න කියන්නේ.
election එක කරා.
half a day එකක් දෙන්න කියන්නේ. ඉතින් උදේ half a day දුන්නාම මොකද තේරෙන්නේ නැහැ. උදේ shift එක දුවන්නේ නැහැ කියන්නේම ඒ සේවකයන්ට half day එකක් ඇවිල්ලා නැද්ද? already ඇවිල්ලා තියෙනවා. එතකොට
අපි ඒකට කැමති නෑ night එකට එන්න full 9 hours කරගන්න.
මේමනේ ඒක නම් ඒක ඩිසිප්ලින් කතන්දරයක් රයිට් මම එච්චර වුණා නම් මම එල්ලවනවා නෑ මෙහෙමයි ඉලෙක්ෂන් එකේ හතරෙන් පස්සේ හාපඩේ දෙන්න කියලා කොහෙවත් නෑනේ ඉලෙක්ෂන් එක පවතින්නේ උදේ 7යි හවස 4යි අතර ඒකට ඡන්දය දැනීමට කෙනෙකුට half a day එකක් දෙනවයි කියලා කියන්නේ මම කියන්න පුළුවන් සේවක ඩ්‍රයිව් අපි උදේ දැන් 8 තුනක් 7කට පටන් ගන්න shift එක 7 කට පටන් හරි රයිට් උදේ 6 ඉඳලා දවල් 12 වෙනකම් අපි වලට දෙනවා මොනවාද ලීව් එක ඡන්ද දාලා වරේ
ඒක තමයි දෙන්නේ.
ඔව්
ඔන්නේ කිව්වේ.
ඔව්
ඔළුව ඒ වගේ ඡන්ද දාලා ඔළුව දැක්කම
ඒක ආවින්නේ නෑ දෙන්නේ අපි කියන්නේ ටිකක් ප්‍රතිත් එක right එහෙනම් definitely right මේ මොනවාද ඉන්ටර් කම්පැනි එම්ප්ලොයිස් යුනියන් එකෙන් හරි एम्प्लॉइज यूनियन में जाने का अधिकारी जनरल सेक्रेटरी ඉතින් ඒක කතා කරලා ඉස්සෙල්ලා ගන්න මට ඒකට උත්තරයක් දෙන්න බෑ. හැබැයි මම නම්
ඒක ගන්න පුළුවන් නේ ප්‍රශ්නයක් නෑ.
ප්‍රශ්නයක් නැහැ නේ උදේකට ගෙන්නන්නේ. ඒක වෙන අයත්. වෙන අය කියන්නේ ඒගොල්ලන්ට නිවාඩුව කී වෙනකන් ඡන්ද දාන්න දීලා තියෙනවා.
ඒකට අපි උදේ ඉඳන් හවස 4 වෙනකම් ඡන්ද දාලා night එකට ඉන්නවා.
ඔව් ඉතින්
ඒක අපි night එකට වැඩ කරන්න කියලා. ප්‍රොඩක්ෂන් සිස්ටම් එක. අර තාර්ගේ තමයි කඩන්නේ ඉලෙක්ෂන් දීලා එකේ තියෙන තාර්ගේ තමයි ඒගොල්ලෝ කඩන්නේ. half day එකක් අපේ entitled
ඉතින් half day එකක් දැන් දවසම උදේ shift එක වැඩ කරන අයට මෙහෙමම දීලානේ තියෙන නිවාඩුව. මෙහෙමයි වැඩේ තියෙන්නේ. රටේ මෙහෙම ගියොත් වැඩි කල බිස්නස් දුවන්න හම්බෙන්නේ නැහැ. අපි both what we need to protect is the workers as well as employers, right? බලන්නකෝ මොකද වෙන්නේ කියලා. බලන්න මොකද වෙන්නේ. So I'm not criticizing, but as an independent person, I see, lot of things will happen negatively, right, in the country, very near future. ඔක ඔය දැන් සමහර ඒවා අපි වෙනස් කරන්න ගත්තනේ ඩෝ එකේ. ඒවට ඉඩ දුන්නේ නැහැ නේ මේගොල්ලෝ. දැන් මටත් මේවා කරේ ඕවත් එක්කනේ. හැබැයි ඒ තාමත් යන්න දිනමට කූප් එකට කූප් වෙනවා මම මොකක් කරලා නැහැ මේ නමුත් යම් දේවල් කරන්න ගියාම දැන් මේගොල්ලෝම පිළිගන්නවා ඒවා මොකද වැඩ කරන්න ඕන දේවල් හැබැයි මෙතන තියෙනනේ වෙන ඊගෝ එකක් තියෙනවා රටක් හැටියට දුවන්න මෙහෙමයි අපි හැමතැනම දකින්නේ what we are seeing is individual things. Individual matters are being continuously addressed. We are not looking at the holistic picture. What will happen to Samaru Ginani? ඇමරිකාවේ GSP මොකක්ද? Around 3 billion we are receiving from the US. From total export income, total exporting, how much is 12, 11, 10 billion? Right? Out of that, 3 billion comes from the US market. Because the majority of our product, garment industry, and some other related product will be exported to individual countries. ඒක අපිට බලපෑම් නැහැ කියන්නේ කොහොමද? Next, the EU, European Union, GSP Plus. Under GSP Plus, generalized scheme of preferences. අපිට ඒක 10ට හරි අඩුවට හැම 20 වගේ තියෙන එක, so it's a deducted cost, tax. ඒක අපිට වාසි වෙන්න කොහොමද? ඕකේ එක්කෙනෙක් මගෙත් එක්ක ආගියු කරන්න ආවා මේ ඒත් යූනියන් එකේ ඉතර නෑ පුද්ගල ප්‍රසිද්ධයි. මොකද ඉන්ටර්නැෂනල් මේවා හින්දා රයිට් තර්ක කරන්න ආවා GSP ප්ලස් සහනය අපිට ලැබුණානේ. මොකද මමත් ඒකේ කොටස් කරුවෙක්. හරි ඒක ලැබුණාම ඒකේ වාසිය සේවකයන් එන්න ඕනේ පඩි වැඩි කරන්න ඕනේ. ඇඟලුම් කරනවා වැඩි කරන්න. එහෙම බෑ. මොකද වෙන්නේ? එහෙම පුළුවන් ලෝන් ටර්ම්. ඕකේ යන්නේ කාටද? GSP ප්ලස් එකේ සහනය ගියාම ඒ සහනය යන්නේ ඒ රටේ මිනිස්සු. ඒකට මිනිස්සු වැඩියෙන් බයස්ලා අපේ ප්‍රොඩක්ට් මිලදී ගන්න. අපේ ප්‍රොඩක්ට් මිලදී ගන්නකොට අපි ප්‍රොඩක්ෂන් එක වැඩි වෙනවා. ප්‍රොඩක්ෂන් එක වැඩි වුණාම ඒකෙන් ප්‍රොෆිට් එක වැඩි වීමක් වෙන්න පුළුවන්. ඒක ෂෙයා කරගන්නකොට හැබැයි ඒක ලෝන් ටර්ම් එකක්. හිත වෙන්නේ නැහැ. I think. So anyway, there are things, right? So law is law, you have to adhere, right? Next, this information should be, right, should contain circumstances of the death of a worker and indicating whether in the opinion of the employer he is or not liable, whether he is liable or not liable to deposit compensation on account of workers' death. Likewise, the employer is obliged by law, unless, right, disclaims liability to deposit compensation on any ground other than there are no dependents of the deceased worker, to make the deposit of compensation within 30 days. Within 30 days after notice was served. This was amended, right, in 2022. You will see it later. This is in the principle, right, enactment. If the employer opinions that he is not liable, then he must submit a statement including the reasons for disclaiming liability. If you are not liable, right, you have to inform disclaiming the liability. Why? Then compensation again adu nadda? There are. So why? Even for some small incidents, people are employees are arguing. Sometimes the millions of rupees are being spent by the employer to defend. Why? පොඩි දෙයක් ඔය රුපියල් ලක්ෂයක් කමාලා ලක්ෂ 5ක් 6ක් ගෙවලා දාලා ඇයි එහෙම ගෙවලා නිකන් ඉන්න බැරි ඇයි? Why is it? Because of the reputation of the company, right? So company always, if something happened genuinely, it's okay, but otherwise sometimes workers are also some workers are not genuine. So therefore, in order to protect the reputation of the company go to argue, they not pay. The company does not pay. Then case goes to, it's like the court. Finally, having argued everything, the decision will be given by the Workmen Compensation Commission. Right. If the employer, right, so if the employer opinions that he is not liable, then he must submit a statement indicating reasons for disclaiming liability. The commissioner, after an inquiry, as he or she may deem fit, inform the dependents of the deceased worker that it is upon for them to prepare a claim for compensation and may give them further information as he thinks fit. Finally, section 20, if the employer fails to pay compensation award if the employer fails to pay compensation award within a period of 30 days, then he is liable to a surcharge of 10% of the amount awarded. So award is granted by the commissioner, workman compensation, and order the company employer to pay the amount of compensation. If the company fails to pay within 30 days from the award granted, then another 10% will be charged. It goes to the worker, right? Employee. Section 21. Where a worker has given notice of an accident, a worker must submit himself. Actually, worker ටත් පුළුවන් දැනුම් දෙන්න. ඔව්. ඔව්. මොකද ඇහුන්නේ? ඩෙත් එකක තමයි. ඩෙත් එකකනේ ඩිපෙන්ඩ් ඇහුන්නේ. Award is, from the date that the award is granted. Again, decision is given by the commissioner. Commissioner decision එක දෙන දවසේ ඉඳලා. Right? Decision එක අද දුන්නා නම් අද ඉඳලා මාසෙක එන කම්පැනි එකට කියවනවා, right? මෙන්න decision එක අද යවනවා notice එක මේක ගෙවන්න කියලා. Right? එතකොට එදා ඉඳලා තමයි 1 month calculate කරන්නේ. Right?
30 working days or 30 days?
30 days. It says 30 days. As per the section 21, where a worker has given notice of an accident, a worker must submit himself to a medical examination if the employer offers pre-medical examination. Right? And also this must occur before the expiry of 3 days from the time of service of the notice of accident. Accident එක notice කරපු දවසේ ඉඳලා දින 3ක් ඇතුළත මෙයා, so the person has to be referred to a medical doctor. If the worker accepts such offer but deliberately disregards the instruction of the registered medical practitioner, or if the worker refuses to accept such offer and thereafter either fails to take treatment regularly, and if the injury is aggravated as a result of deliberate disregard of medical advice, then the compensation, if any, shall be payable accordingly. What does it mean? A person, is aggravated because of his neglecting the medical advice. Is not taking the proper the medicine or whatever. Then therefore he is if the person has taken proper medical care and medical advice, so within 1 month he would be able to report to work, right? But due to negligence, his own negligence, it takes 2 months. Say for example, it takes, that is what it says. Look, if the worker accepts such offer but deliberately disregard the instruction of the registered medical practitioner, or if the worker refuses to accept such offer and thereafter either fails to take treatment regularly, and if the injury is aggravated as a result of deliberate disregard, හිතාමතාම නොසලකා හැරීම of medical advice, then compensation, if any, shall be payable accordingly. ඒක එවන්න ඕනේ. ඉතින් ඒක හැබැයි මෙහෙම. ඒක තනියම හාමුදුරුවෝ කරන වැඩක් කරන්න බෑ. ඒක compensation එතෙන් යනවා ආගියු කරන්න. එතකොට සමහරවිට compensation එකකින් යම්කිසි ප්‍රමාණයක් අඩු කරන්න හැකියාව තියෙනවා. ඒකයි මේ කියන්නේ. Yes, yes, definitely. ඔව් පුළුවන්. ඒක ඉතින් ලේසි වැඩක් නෙමෙයි, but the law says as such. But when it comes to practical situation, quite somewhat is very difficult. And then what is the process that workers need to follow in order to claim compensation? Oh. Oh. පුළුවන්නේ දැන් ඩොක්ටර්ස් ලගේ මොකද්ද පිළිගන්නේ? ඩොක්ටර්ස් ලගේ කියන්නේ මේ verbally කියනවා තමයි. හැබැයි කියන දේවල් ටික දෙන දේවල් ටික මොකද ලියන්නේ? prescription එකේ ලියනවා. එහෙම නැත්නම් එයාගේ තියෙනවා රෙකෝඩ් එක ඇඳ ඉහ පතද මොකද්ද කියන්නේ? මොකද්ද බන්දන එක. so ඒකේ ලියනවනේ මේවා. මේක කළා කියලා. මේව දුන්නයි කියලා. it has to be accepted. argument තියෙයි කොහේ හරි. but form A කොහොමද ගන්නෙ? Titled application for compensation by workmen must be duly filled in, giving name and address etc. of the applicant, date of accident, cause of injury, types of injury, monthly wages of worker, date on which notice of accident was served on employer, etc. The worker in his or her application requests the commissioner to determine whether he is considered a worker within the terms of the ordinance, whether the accident arose out of or in the course of the applicant's employment, whether the amount of compensation claimed or any similar amount is due, and whether the respondent is liable to pay such compensation as may be due. These are the information when if you met with an accident, how you can claim, right? The application process.
That has to be some small or similar.
Sorry, similar, right? Accident or cause of the applicant, the amount of compensation, small, not the smaller, similar, right? Should make it similar. Right.
So now
Sorry. Let me. Whether the amount of compensation claimed or any similar amount is due, and whether the respondent is liable to pay.
So in this case, now employer also already informed.
Yeah.
Employee also has to inform. So you can't.
Yes.
Even though the compensation has been paid by the employer, still employee has to inform.
No. If the worker is accepting, say for example, the insurance, right, or the company directly pay as per the schedule, right, and the worker has accepted, then there is no requirement to inform the commissioner workman compensation, right? If dispute arises, then it has to be, right? But the employer is liable to inform the accident took place or occurrence to the factory inspecting engineer under the Department of Labor. Not, factory inspecting engineer, I mean, report has to be sent. Right? It's the mandatory requirement, right, of the employer. So in that case, employer is not supposed to, this much, the amount has been paid, or those are unnecessary, not required. But how many, what was the, the occurrence took place, and how many people affected, right? The what are the, the actions taken, those has to be required. But when it comes to compensation, yes, people have to be compensated, affected people, the workers have to be compensated according to the compensation ordinance. Then if the employer adheres, right, to the law, then no need of informing the commission. It's not mandated. But my argument is, right, I wanted to, but it didn't happen. Reporting must be mandatory to the workman company. Why? May employer, we have, employer may think that it's an unnecessary process, and an unnecessary burden to the employer. But it has to be, provided, certain easy access to the employer, fill up, send the information, because lot of information, we are lacking information with regard to occupational disease, injury and disease. We don't have. Sometimes this accident took place, directly sent to the hospital, then person, leave, but it was not, those information and is not reported to the Department of Labor or the Workmen Compensation. Then how do we take, the policy decision? මේ කෙක්කෙනාගේ රාජධානිය වල තියන්නේ ඩොක්ටර්ස්ලා කැමති නැහැ ඒ තොරතුරු මෙහෙට දෙන්න. So by looking at, we have to make, the policies good, everything, under this one. My view is close this office, right, and make it mandatory for the employer to insure people. Right? And if insurance is not, being paid, allow the worker to complain to the labor department, because it has, the wider, the network, island wide. Now, the Workmen Compensation Commissioner goes here and there, only two of them, deputy commissioner and the commissioner. Cases, all two female, they are going, Dambulla, Badulla, Nuwarelia. Every week, I receive application or request to approve extra fuel. Extra fuel, we have to give. Extra fuel. 200,000 sometimes, per month extra. So, just මාස දෙකක් විතර අස්සම් කරන්න නැතුව ගියා. ඒකත් පාව ඊට පස්සේ කම්ප්ලේන් කරනවානේ මට ගියේ නෑ මේ යන්න ඕනේ නෑ නඩු විසඳන්න බැරුණා යන්න කියලා. So we should give this one to health. There are, large number of LDs in the country. Sometimes the people have to, come from far away, right, to the Colombo with lawyers. So anyway, so this is, and how does the ordinance define an employer? An employer includes the Republic of Sri Lanka. And you already, right, observed previously, government and the private sector, all incorporated bodies or unincorporated, right, or some higher or even the manpower companies. Next, right, instance where the employer is not liable to pay compensation, right? Exceptions, the employer is not liable. Look at it. If the injury is negligible, what does it mean? පොඩි ඇඟිල්ලක් පිටක් කැපෙනවා පොඩක් දවසක් දෙකක් 3 days සාමාන්‍යයෙන් අපි ගන්නවා. It's not negligible. After 3 days the person can report to work. An example, if the injury results in total or partial disablement which does not exceed 3 days. Any injury which does not result in death and which is directly attributed to, any injury which does not result in death and which is directly attributed to the fact that the workman was under the influence of liquor. Influence of and willful disobedience of the orders expressly given to him in order to secure safety. In order to secure safety. Right. එතකොට ආම්පුතාට නිදහස් වෙන්න right මම වලට කියලා තියෙනවද මන් දන්නේ නැහැ. ඔරණ බැල්ලපිටියේ කේස් එකක් කිව්වනේ. ඔරණ බැල්ලපිටියේ 2018 අවුරුද්දේ අප්‍රේල් 19 වෙනිදා ඇමෝනියා වලකට වැටිලා 6 දිනක් මැරෙනවා. ඇමෝනියා වලකට වැටිලා 6 දිනක් 5 දිනක් එතනම මැරෙනවා. එක්කෙනෙක් හොස්පිටලයිස් වුණාම මැරෙනවා. ඒකෙන් දෙන්නෙක් සේවකයෝ. ආයතනේ සේවකයෝ. අනිත් අය මුඹේර ගන්න ඇවිල්ලා වටේ හිටපු මිනිස්සු මැරෙනවා. ඒකට වෙනම පරිසරයකෙමුත් අඬුවක් දාලා තියෙනවා. ක්‍රිමිනල් එකෙකුත් අඬුවක් දාලා තියෙනවා. දැන් clear violation of factories ordinance. ඒකට factory inspecting engineer දෙන්න ඕනේ විමර්ශන වාර්තා. මේ යකා අලුතට හරි මෝ ඊට සති දෙකකට ගිහිල්ලා ඕඩින් එකක් දීලා උඹලගේ සෞඛ්‍ය ආරක්ෂාව නැහැ සේවකුන්ට ඉතින් මේව හදන්න ඕනේ. හරි හේව් කීප එක සති දෙකකට කලින් මම සති දෙක ඊට පස්සේ ඇක්සිඩන්ට් එක සිදු වෙනවා. ඊට පස්සේ මම මොකකින් රිපෝට් එක ඉල්ලනවා. මම එයාට නෙමෙයි කියන්නේ එයා ඉමීඩියට් සිනා කියන්නේ මගේ ඇඩිෂනල් කමිෂනර් ජෙනරල් ඔෆ් ලේබර් ඉංජිනේරින් right chief factory inspecting engineer එක කියනවා අරුත කියලා රිපෝට් එක ගන්න. මෝ ඉඳලා මාස ගානක් තිස්සේ ඉඳලා විමර්ශන වාර්තාව කියලා දෙන්නේ විමර්ශන වාර්තාවක් නෙමෙයි. ෆැක්ටරියේ විසිට් කරලා මොකුත් නැහැ. මෝ ඩ්‍රයිව් කරලා ආයතනයේ මිනිස්සයා ඩ්‍රයිව් කරලා දෙන්න ඕනේ. මිනිහා දෙනවා අද දින මාගේ කාර්යාලයට පැමිණි කළමනාකරන ආයතනයේ කළමනාකරන අධ්‍යක්ෂක සහ තව දෙන්නෙක් මාගේ කාර්යාලයට පැමිණ පහත සඳහන් පරිදි ප්‍රකාශ කරන ලදී. එයාගේ ප්‍රකාශ විද්‍යාවේ මේ අනුව මාගේ නිගමනය වන්නේ සේවකයන් equipment ලබා දී තිබූ උපකරණ නොකළදා right මේ කටයුත්තක මේ නිරත වීම නිසා සිදු වූ නිසා ආයතනයේ වරදක් නොව සේවකයන්ගේ වරදක් කියලා දෙනවා. ජරාගේ ඔය අතරතුර ඔය මිනිස්සයා ඔය ආමිකේ දුන්නේ මම කොමසාරි ජෙනරල් වෙලා ඉන්න කාලේ එයා එයාගේ කවුරු හරි ලේඩි කෙනෙක් ඉන්නවා SLAs කවුරු හරි ඔය ආකාර කවුරු ප්‍රාදේශීය ඉතින් මට කතා කරලා සර් මං එන්න ඕනේ මහමත් කොටස් ගියා. ඒකට ෆැක්ටරි වහලා තියෙන එන්වයරන්මන්ට්. හැබැයි මම දැඩි ලෙස විරුද්ධ වුණා ෆැක්ටරි වහනවා. මම ජනාධිපතිට කිව්වා. වහන්න එපා ආරක්ෂාව සහිතව හරි මොකද මේක ආදායම් මාර්ග නෑ. ළමයි ඉස්කෝලේ යන කන්න බොන්න දෙන්නේ කොහොමද? මම 50 ගානක් සේවක. මං එතන හිටියේ මං කිව්වා ඔයා මේ ෆැක්ටරි වහනකට මං විරුද්ධ. මං ප්‍රෙසිඩන්ට්ට මේ ගියේ මං පෙන්නුවා. ඒතරලා මං කිව්වා හැබැයි ඔයා සේවකයෝ අනාරක්ෂිතව සේවය දුන්නා කියලා. ඒකට ෆැක්ටරිස් වල ඔඩියන්ස් එක වයලේට් මං ඒක යටතේ නීත්‍යානුකූල ක්‍රියාමාර්ග ගන්නවා. ඒකෙන් කරන්නේ නඩු දානමාම කරන්නේ මොකද දන්නවද? දඩයක් ගන්න පොඩි කියලා. එහෙම නැත්නම් ඉරේ දාන්නේ නැහැ. අවවාද කරනවා. දඩයක් ගන්න. එහෙම තමයි ෆැක්ටරිස් වල යන්නේ. එහෙම කොහොමද කරන්නේ කියලා නැගිටලා ඔයා ආමික් වාච්චයෙන් බලාගමු. මොකද මොන බලාගෙන දොරවල් තියෙන බහපන් එකේ. ඉතින් බහින් ගිහුව එළියේ මට තර්ජනය කරන්න. ඊට පස්සේ දැන් අරුගේ රිපෝට් එක එහෙමනේ. විමර්ශන වාර්තාවක් නෙමෙයි ඒක. විමර්ශන වාර්තාවක් නම් තියෙන්න බෑ මෙන්න උපකරණ පින්තූරයක් තියෙනවා මේ උපකරණ දී මොකුත් නැහැ. අරු කියනවා ඒ මොනවාද සහතිකයේ ISO සහතික අරම සහතික තිබ්බට වැඩක් නැහැ මිනිස්සු මැරලා. පස්සේ මම ඒක ප්‍රතික්ෂේප කරලා ඌ විමර්ශනය නොකිරීම නිසා ආයතන සංග්‍රහයට අනුව විනයානුකූලව කටයුතු කළා. ඌට විරුද්ධව මම ආයතන සංග්‍රහයට අනුව විනයානුකූලව කටයුතු ඉදිරි කරා. තාමත් යනවා මේ ඉන්ක්වයරි. ඊට පස්සේ මුගේක මම ප්‍රතික්ෂේප කළා නඩුවංශයට ගෙනාවා ෆයිල් එක. ඒකෙන් නඩුවංශයට ගෙනාවා. ඒලා ප්‍රධාන නීති නිලධාරියට දුන්නා මම ඉන්ස්ට්‍රක්ෂන් එකක් මේක නඩු පැවරීම සඳහා මෙරිට් තිබේද යන්න මට දැනුවත් කරන්න. ඊට පස්සේ ගොඩක් රිපෝට් ආවේ එමෝ කරලා මේ සාක්ෂි රැස් කළා මට මෙරිට් තියෙනවා කියලා දුන්නා. මම ඊට පස්සේ චීෆ් ෆැක්ටරිස් එකේම නඩු පවරනවා. දැන් ඔතනින් මම එන්න හදන්නේ right ඒගොල්ලෝ තර්කයක් ගේන්න හදනවා මෙතන any injury කොහෙද මම කියවෙන එක willful disobedience of the orders expressly given to him in order to secure safety. ඒ කියන්නේ උපකරණ දුන්නා ඔබ පැනදුවේ නැහැ එතනින් මේ ඒක එන්න හැබැයි අපිට අයදේ මැරුණේ ඒක ඒන අයදේම උපකරණ මොනවාද නැතුව so ඊට පස්සේ මම කරේ මට නඩු දැම්මා. නඩු දැම්මම මොකද ආයතනේ නඩු දාන්නේ. නඩු දැම්මම අරගොල්ලන්ගේ සාක්ෂිකාරයෙක් වුණා අපේ චීෆ් ෆැක්ටරි ඉන්ස්පෙක්ටිං ඉන්ජිනියර්. ෆැක්ටරි ඉන්ස්පෙක්ටිං ඉන්ජිනියර්. උගේ රිපෝට් එක ඔය කියන්නේ නඩුවට විරෝධතාවය ඉදිරිපත් කරනවා. අර මිනිහාගේ රිපෝට් එක අර කම්පැනි එක විරෝධතාවයක් ඇති ඉදිරිපත්. මේ ෆැක්ටරි ඉන්ස්පෙක්ටිං ඉන්ජිනියර් කම්පීටන්ට් පර්සන් කියන්නේ මේ මොනවාද සේවකයන්ගේ වරදක්. හැබැයි ඊට පස්සේ ඒක ඉදිරිපත් කරන කලින්ගේ මහේස්ත්‍රාත්තුමේ තියෙන තුමියක් මේ මොකද්ද මේ ගෙදරට ඇවිල්ලා කට උත්තර මේක පිළිගන්න බෑ. ඒව ආගියු කරන්න නඩුවේ කියලා නඩුව අහන්න දිගණියම කරා. සතියක් යනකොට මහේස්ත්‍රාත්තුමේ මාරු. හරි real situation නම මාරු. වෙන කෙනෙක් එයා ඇවිල්ලා ඒක කරන්න බෑ වැරදි. නඩුවක් අහන්න තීරණය කරපු නඩුවට නැවත ඔබ්ජෙක්ෂන් කරන්න බෑ. ඒක කරන්නේ කියන්නේ බෑ තමයි කරන්නේ. එතකොට අර ඉංජිනේරු වගේ අරක දෙනවා. ඒක දිහා බලලා පළවෙනි දවසේම ඊළඟ දවසේ කෝලින් ඩේට් එක දවසේ මේ තියෙන්නේ අයියා පො මේකේ උඩම තියෙනවා අද දින මාගේ කාර්යාලයට පැමිණ කියලා දීපු කොටස්. ඒව මොකක්ද බලන්න නැතුව. මේ තියෙන්නේ මේක පදනම් කරගෙන. අරගොල්ලෝ නිදොස් කොට නිදොස් කොට නඩු අහන්නවත් දෙන්න දුස්සා. මොකුත් නැහැ. නිදොස් කොට නිදහස් කරලා සාපරාධි නඩු පැවරීම යටතේ පොලිසියට උඩ කරා. මායි මගේ ෆැක්ටරි ඉන්ස්පෙක්ටිං ඉන්ජිනියර්ටයි විරුද්ධව කටයුතු කරා. හරි? මට විරුද්ධව කටයුතු කරා. හැබැයි නඩු තීන්දුව කලින් එකේ විසි කරාම තීන්දුව ලියන තීන්දුවේ කොහොමවත් මගේ නමක් නැහැ. ඊට පස්සේ නඩු පවරුවේ මම වෙනුවෙන් පවරනවානේ ෆැක්ටරි ඉන්ස්පෙක්ටිං චීෆ් එක්කන මේ නිහඬ පොලිසියට එන්න කියලා කට උත්තරයක් ගන්න. කට උත්තරය අරගත්තේ ඉතින් පවුදා 16ක් ඇවිල්ලා කියන්නේ. උසාවියේ පෙන්න. ඔක්කොම සෙට් කරලා 16ක් ඇවිල්ලා. ඊට පස්සේ මට ඒ ආවට පස්සේ මිනිහා කරන්නේ ඒකට යන්න නැතුව මෙඩිකල් එකක් දෙනවා. උසාවියට යනවා. මිනිහා අරෙස්ට් කරනවා. හරි ඊළඟ දවස් යනකොට අර. ඊට පස්සේ කොහෙන්ද දන්නේ නැහැ. මගේමත් කට උත්තරයක් ගන්න කියලා පොලිසිය මට කිව්වා. මම අමාත්‍යංශයට ගියා. ඒක කෙනෙක් මම මෙයාට කිව්වා රෙඩියෙන් ගන්න කිව්වා. හරි. මට මේකට මං යා යුතුද මේ. ඊට පස්සේ පොලිසියම ආවා. අදතර අපරාධ කොට්ටාසෙන් පොලිසියම ඇවිල්ලා හතර පහ දෙනෙක් ඇවිල්ලා මම ඉතින් කච්චි ඔක්කොම ගියන් කිව්වා කියපු කරපු දේ කිව්වා. අපි නඩු දැම්මේ මෙයාගේ මේ වාර්තාවකට නෙමෙයි. ඒකේ නඩු දාන්න බෑ. මෙන්න අපි සාක්ෂි රැස් කළා මෙහෙම නඩු දැම්මේ. අනිත් එක වන්දි කොමසාරිස්ගේ වන්දි කෙවලා. ඒ කියන්නේ ගිල්ටිනේ. හරි. ගිල්ටිනේ වන්දියේ වන්දි කෙවලා සේවකයා. ඒකට ගිල්ටි. ඊට පස්සේ අපි මම පොලිසියට කිව්වා. කිව්වහම එක පාරම ඊළඟ නඩු දිනේ මොකුත් කොහෙන්වත් පොලිසියෙන් කට උත්තරයක් ගත්ත විතරයි. මයිස්ට්‍රාත්තුමා අහනවා. ඒවා අහන කියන්නේ අපි ආදේශ තහන් ගන්නවනේ අපි ඔක්කොම අරන් තියෙනකොට මොන නඩුවක් తీරෙන්න. කියනවා විමල වීර නමත්තාගෙන් කට උත්තර ගත්තා. කවුද කට උත්තර ගන්න කිව්වේ කියලා මොනවත් නැහැ. හැබැයි පොලිසියෙන් මයින් කට ගත්තා නෑ. එයා අහන්නේ කියන්නේ ඒගොල්ලෝ දැනගෙන ඉඳලා නෙමෙයි ප්ලෑන් කරලානේ. ගත්තද කට උත්තර? ගත්ත ස්වාමී. ඔහුගේ මේ නඩුවට සම්බන්ධයක් තියෙනවද? මේ කරුණ අනුව බැලූ බැලමුවට එහෙම පේන්නේ නැහැ ස්වාමී. තවදුරටත් විමර්ශනය කරලා නැහැ. ඔහු මෙම සැකකරු මෙම නඩුවේ සැකකරුවෙකු ලෙස නම් කරමි. මහේස්ත්‍රාත් කියලා නම් කරමි. කියලා එකපාරම පොලිස්පතිට නියෝගයක් නිකුත් කරනවා මම අත්අඩංගුවට අරන් සාවිට ඉදපත් කරනවා. ඉතින් මට නඩුවකට එන්න කියලා ඉතාසියකුත් නැහැ. හරි කට උත්තරයක් පොලිසියෙන් ගත්තා. කට උත්තරෙන් මට පදනම් වෙලා මහේස්ත්‍රාත්තුමා කියනවා මේ මම සැකකරුවෙක් කරන්න බෑ කියලා පොලිසියට කියන්නේ. මහේස්ත්‍රාත් මාව සැකකාරයෙක් කරලා අත්තර ඉන්නේ කොහොමද අත්තර ගොඩ ගන්න උසාවි කියන එක පැහැර හරිය නැත්නම් නේ. හරි මට කිසිදු දෙයක්වත් නැතුව මම අත්තර ගොඩ ගන්න. මම කියන්නේ අයි පොල් ගිරි අකුරේ මේ දවස්වල පත්‍රේ වැටෙන්නේ කම්කරු ලේකම් දේශකියා ලේකම් අත්තර ගොඩ ගන්න කියලා. නැත්තම් ඔව් ඉතින් ගියානේ මම ගියේ නෑ මම ඔෆිස් එනවා ඔෆිස් වලට ඔෆිස් ඇතුලේ ගිහින් ගෙදර ඇද්දස් එකේ ගෙදර ගියා අපි මේවනේ මේ තරම් උදවල් ඉතින් රාජ්‍ය මුදලින් හරි මේක දෙයකට තියෙන ඇද්දස් එක සර් මේක සර්ව් කරන සර් බාර ගත්තොත් බාර නොගන්න නම් ප්‍රශ්නයක් නෑ ඒක අපි ඔෆිස් එකට එන්නේ නෑ ඒ දෙන්නේ ගෙදර ඉන්නවා මම කන්තෙන් වල හිටියා අවුරුදු 20 පත්තරෙත් යන කොහොමද රාජකාරියට මේ කියන්නේ ඔෆිස් ඉදිද්දී මේ ගත්තන ගොඩ ගන්නේ නැත්තේ ඇයි කියලා නේ ගත්තන ගොඩ ගන්න උසාවියකට නොගිහින් ඉන්න හරිද මම වැරදි කාර්යයක් කරන්නේ කවුද සැකකරුවෝ කරන්නේ මහේස්ත්‍රාත් ඒක මඩේ මොකද්ද කරලා තියෙන්නේ කට උත්තරයක් කරගෙන කියන්න බෑ මට පො එනම් උසාවියෙන් මොකුත් නැතුව මාව සැකකාරයෙක් කළා පොලිසිය දෝඩරයක් දෙනවා අත්තර මම ඇන්නේ ඊට පස්සේ මම ගියා ප්‍රතිදින ගාවට ගියා ඒ කාලේ මොනවා නීතිපති තමයි මොකද තියෙන්නේ නීතිපති හම්බුණා හරි නීතිපති හම්බුණා ඒ දෙවි සම්මලිතව මම නීති පොලිසිය අත්තරම රාජරත්න මහත්තයා ඇහුවා අපිත් ඉස්සරහ මොකද්ද මේ අයිජි මේ මොකද්ද පොලිටික්ස් ඒ දකුණු පැත්තේ නම් කියනවා ඒ කියන්නේ ඉගේ සම්බන්ධයක් තියෙනවා මම කියන්නේ
ඒක සම්බන්ධයක් තියෙන පොලිස්
පොල් කියන්නේ ඥාති සම්බන්ධයක් තියෙනවා තද පොලිටි ඒ කාලේ කියන්නේ අනිත් පැත්තේ කෝට්ටුව පැත්තේ තද පොලිටික්ස් සම්බන්ධයක් තියෙනවා ඒක නිසා තමයි මට ඕනකම තිබුණා මම දවසකට හරි ඇතුළට දාන්නයි මට බැන්නනේ මොකද නේද ඒක කොහොම හරි ඊට පස්සේ ගියාම දැන් මං කරේ නලින් නින්ද පිස්සු අල්ලගෙන මට රිවිෂන් එකක් කරන්න පානුදුර රිවිෂන් එකක් කරලා පොඩි වෙලාවයි මේ මනුස්සයා කතා කරේ උත් නිකන් ඒක උන් ඔක්කොම ප්ලෑන් කළා මේක කරේ මට කෙලෙවල් ලක්ෂ 4 දෙන්න 6 ලක්ෂ 75000ක් ගත්තා තව 3 ලක්ෂ ගණන් කියලා දුන්නේ නැහැ මොකක් පොඩි වෙලාවයි අර මැජිස්ට්‍රේට් කිව්වනේ ඒකෙම මෙහෙන්න බෑ කිව්වා ගිහිල්ලා අපරන් එන්නේ කිව්වා මහේස්ත්‍රාත් අධිකරණය ඊට පස්සේ ඉන්දිතෝන මට පොලිසියෙන් ගන්න තිබ්බනේ කත්තේ නැහැ ඊට පස්සේ මම කරේ දැන් මට ඉක්කා දැන් ඒ කාලේ මට අදියත් එක්ක මොනවා හරි කරගන්න පුළුවන්. හරියට දුක කරගන්න නෙමෙයි ඉතින් මොනවා හරි. කවුද? සංජීව ජයවර්ධන. දන්නවනේ සංජීව ජයවර්ධනගේ ගාස්තු. කුමාරි ඔව්. දන්නේ. ඉතින් ෆොටෝ පැපිල් වල ලීඩින් මයින් එයා තමයි. අරන් දැම්මා. වයි කරන්නත් ගියා මිලියන්ස් වලට එහා. එහෙම ගියා. තාම ෆයිල් කරලා ඉවරයි. ඊට පස්සේ ඔබ්ජෙක්ෂන් කෝල් කරලා තියෙනවා. ඒ ගියාම පළවෙනි දවසේම මම අත්අඩංගුවට ගෙනෙන්නේ වැළැක්කුවා. හරිද? මේ අභියාචනාවට කරන්නේ. හැබැයි මට කිව්වා ගිහිල්ලා අපාරන් එන්න. ඊට පස්සේ නඩුව අහන එකෙන් අර මහේස්ත්‍රාත් අයින් කරලා උඩ තත්ත්වයේ දිස්ත්‍රික් ජජ් ඉන්නවා. ඊළඟ උඩ තත්ත්වයේ දිස්ත්‍රික් ජජ්ට දුන්නා මැජිස්ට්‍රේට් එකකින් මහාන. අප දෙන්න. අප දුන්නා කියන්නේ මොනෝ කරලාද 6 දෙනෙක් මැරිච් එක්කට මම නඩුවක් දැම්මහම මිලියන 2 ගානේ ශරීරය අප දෙකයි. ඔව් මිලියන 2 ගානේ ශරීරය අප දෙකයි. එකමයි. ඊට පස්සේ 60000 sorry 50000යි මුදල් ලැබ. 50000 තිබෙත් නැහැ. ඊට පස්සේ ඩ්‍රයිවර් කොහොමද ගිහිල්ලා එයාගේ කෙනෙක් මොන හරි අරගෙන ආවිල්ලා වේවකේ වයිෆ් ගන්න සල්ලි තිබුණෙත් නැහැ ඒක. කොහොම හරි අප දුන්නා කියන්නේ 12ට විතර දැන් අප දුන්නා. අප දුන්නාම පල්ලෙහාට මැජිස්ට්‍රේට් එකේ පැය බඳින්න. එතකම් මාව ගිහිල්ලා තියන්න ඕන අපේ. මං ටයිකෝඩ් දාලා හිටියේ. හරිද? අප දීලා මේ වයිෆ් එහෙම අපේ මස්සිනාර ගිහිල්ලා අරක බැඳලා එනකම් මගේ නීතිච්චෝ හිටියේ. එනකම් මාව අර ජේලර් පල්ලෙහා දක්වට අරන් ගිහිල්ලා අර බලු කුඩු ගාව තියලා තිබ්බා. ඉඳගෙන. නෑ. සාමාන්‍ය රජේ නිලධාරියෙක් එහෙම දාන්නේ නෑ අතුරට. සාමාන්‍ය මිනිස්සු දානවා. ඉඳගෙන හිටියා. දැන් මේ මැජිස්ට්‍රේට් අයිතියක් නැහැනේ මගේ නඟුව වෙන කෙනෙක් නෑවන්නේ. මම ඉස්සරහට කරනවා. කවල් ටයිකෝඩ් දාලා ඉන්න මහත්තයා ඉස්සරහට. ඒ කාලේ අපේ ඇමතිතුමා ඕක ක්‍රිටිසයිස් කරා. මෙහෙම දවසකට පාර්ලිමේන්තුව ඇතුලේ. හරිද? පාර්ලිමේන්තුව ඇතුලේ මෙහෙම දැක්ලා ඇතුලේ මෙහෙම කියලා ක්‍රිටිසයිස් කරා. ඊට පස්සේ ඕකත් අල්ලගෙන දේශපාලඥ වල්ලගෙන උසාවි මග හරින් උසාවි මග හරින් මට උසාවි එන්න එපායි. මම අතලමුඩ ගන්න නියම කර එකපාරටමනේ. උසාවි මග හරින් නීතියට කැම කරලා දාන්න කොහොමද? දැන්වා ටයිකෝඩ් දාලා කුඩු ඇතුලේ මිනිස්සු කියනවලු එළිය යන්න නීතිච්ච මහත්තයෙක් කුඩු ඇතුලට දාලා. ඔව් ඉතින් කුඩු ඇතුලට දාලා ටික වෙලාවක් ඉඳලා එළියට ගත්තා. ඌ මාව දැම්මා විතරයි ඌ අහන්න බෑනේ මම දාන්න බෑනේ. උඩ ඩිස්ට්‍රික්ට් ජජ් කියලා තියෙන එපා කියලා දාන්න. හරි නමුත් මූ දැම්මා ඌට අදාළ නැහැ. ඊට පස්සේ මේ කොහොම හරි මම ටික වෙලාවක මං කිව්වා මොකටද? ඔය ඉන්නවලු අරක අරන් යනකම් කොල්ල ටික අරන් යනකම් මං ඇතුලේම ඉන්නම් කිව්වා. මෙච්චරයි දාපු එකේ. හරි මට වෙලාව දෙනවා කරකිලා දාලා බුදුට වැටෙන්න කියලා. ඊට පස්සේ මං කරවනවා නෑ මොකද? එහෙම අන්තිමට මොකද උනේ? හරි දැන් කොහොම කරලා එළියට ආවා. දැන් මං නඩු කියනවා පොලිසිය. ඊට පස්සේ නඩු පැටලුවේ කොහොමද දන්නවද? අපේ චීෆ් ෆැක්ටරි ඉන්ස්පෙක්ටර් මේ ජීවිතේට වැදගත් වුණ චීෆ් ෆැක්ටරි ඉන්ස්පෙක්ටර් ඉංජිනේර් අරුට බලපෑම. ඒ මං උඩ කියන යකෝ අර රිපෝට් එක නෑ. සර් බයිනවා බං දීපම් මේ රිපෝට් එක මම ඔක්කොම ඉනි මරපෙවුම්. හරි මම ඇතුළට යවන්න ඕන බං. හරිද? ඕක දීපම් කොයකෝ ඕක මම ඔක්කොම ඇතුළට දාන්න ඕන. ඉනි මරපු. දැන් එහෙම බල. අරට විසි කරලා. ඊට පස්සේ අරුවට බලපෑම කොන බලපෑම් කරවන්න දැම්මයි කියලා. අරුව ඉස්සර දැන් එන්නේ කොරණ තාම නඩුව යනවා. ෆැක්ටරි කාර්යාලයේ ඉන්නේ. අපේ ඉංජිනේර. හරි ඌ එන්නේ. දැන් මේ හඬපට පරීක්ෂා කරන්න යවලා. දැන් හඬපට පරීක්ෂා කරන්න යවලා හඬපට අරුගේ කියලා දැන් ඊට පස්සේ රෙකෝඩ් කළාද? ඔව් රෙකෝඩ් කළා ඔක්කොම රෙකෝඩ් කළා. මට අද්දිකට හරහා මම එකක්වත් ගත්තේ නෑ. හොඳ වෙලාවට මගේ මුකුත් නෑ. මුකුත්ම නෑ. අර ඇගේ හඬපට තියෙනවා. හැබැයි දැන් ඔය හඬපට අදාළ නෑනේ නඩු දැම්මේ ඔකේ නෙමෙයිනේ. ඒක අහන්න මේ අකාට ඩිස්ට්‍රික්ට් ඒ තියෙන. එයා කියන්නේ මේ හඬපට තමයි වැදගත්. නඩු අහන්න බෑ කොහෙද යන්නේ. ඌට පස්සේ කියනවා. එතකන් මට රිට් එක යන්න බෑ. ඇයි? නීතිපති වගඋත්තර කාර්යය. නීතිපති වගඋත්තර බඳින්නේ නැහැ. අර ඔරණ නඩු ඉවරයි. දැන් එතන නීතිපතිගේ අවල තියෙන චෝදනාව මට චෝදනා නෑ මොකද? මම මගේ අඬපටි නෑ මොකුත් නෑ. හැබැයි ඒකෙන් උනේ මට මිලියන 2.5ක් විතර. එවන්න නෙවෙයි නඩුව වලට ඔය වියදම් කරනවා. දැන් ඉස්සරහට තව 1 මිලියන් වත් ඕන. විශ්වාස කරන්න. මේ ලෙක්චර් එකෙන් හම්බ වෙන එක කරුණාව 7.5ක් නෑ. 7.5. ඉතර මම කියන්නේ මිනිසුන්ට වෙලඳි. හොඳට මතක තියාගන්න නැති වෙච්ච දවසට මොකෙක්වත් නැහැ. මොකෙක්වත්. හරි. කෝල් එකක් ගන්නවත් කෙනෙක් නැහැ නැතුව. හොඳට මතක තියාගන්න. හරි. Let's go. Right. Next. I think willful removal of disregard to any safety device given to the workman, right? මේවා මත ඉඳගෙන තමයි ඒ කියන්නේ liability එක නතු යන්නේ. Notification of accident, section 57(1). When a workman gets right disabled for more than 3 days or dies due to an accident, the employer should notify the Commissioner of Workmen compensation within a period of 14 days. Within a period of 14 days. And statement of a fatal accident, section 20. The employer should submit within 30 days in form or information that an employee had died as a result of an accident arising out of and in the course of his employment. So these are the basic things that you need to understand with regard to the principle enactment. Later, there are certain amendments in 2022, major amendments. Just, you can go through the act, right? Then if you need, small details, but major has been, the changes has been, covered. Okay, now, shit. Now, shall we stop now, and can we have, can we come at 1 o'clock? 45 minutes is enough now, because we have a, what do you call, the case. I mean, what do you call, the discussion, right, with regard to the definition. Okay, 1 minute, just 1 minute. I have to. What is that? If why is this? It's not moving. All right. Right now, look. Administration of the ordinance, Commissioner of Workmen compensation. Instances where the employer is liable to pay compensation, liability. The employer is liable to pay compensation to workmen who meets with an accident which occurs injury or death. The accident must have arising out of his employment, and this is the new one, in the course of their employment or while coming from their place of residence to the workplace, or while returning back to their place of residence from the work. Right? Contracting an occupational disease is also treated as an accident in the course of his employment. The disease must be directly or reasonably attributed to the work which he was engaged. The list of occupational diseases are given in Schedule 3 of the Ordinance. Right. So now, the next, just after the lunch, because of so as a one group, right, we will argue, it's you, right, whether this one, right, place of the amendment, place of residence to the workplace, or while returning back to place of residence from the workplace. Is it fair? Right? Okay, we will argue it later. So have a lunch, and around 12:50 somewhere. Go quickly. ඔයාලා දැනගෙන හිටිය පත්තරවල ගියේ අය මම කියලා දැනන් හිටියේ නෑනේ. දැන් හිතන්නකෝ ඒක එළිය ගියේ වෙන මතයන්නේ. ඒක උනේ ඒක දෙපාර්තමේන්තුව නඩු නොදැම්මානන්නේ වැරදි. නොදැම්මානන්නේ වැරදි. අපි පෞද්ගලිකව මේක එළියේ ඔක්කොම නිකන් අර චතුරද කියන මොනවද කියන කොම්බෝඩාලිකාවෙන් එහෙම ඔව් දෙරනේ මේ මාන විදියට මාව විවේචනය කරනවා. අපි අද කතා කරන්නේ ඊවිල අපේ ලීගල් ඩිපාර්ට්මන්ට් එකේ මිනිස්සුන් නැහැ. යෝගයක් කියන්නේ පොලිසියෙන් කටුතරේ medicine हर एक का कोई नहीं हो गया थे हाँ क्या हाँ वो है ना ये भाई ये सी काम
हाँ गया तो मैं तुम्हारा
තව ටිකක් ඩිස්කස් කරලා අපි අවසානයට වගේ යමු මේකට. හරි. නැත්තම් වෙලාව මනිෂ්.
discussion එකේ EFCA
ආ
මම අහුවා ඉස්සර ඒකට ඉන්නවා දීලා යනකොට පොයින්ට් හදන්නේ නැහැ
වෙන්න වැඩි දන්නවා.
නෑ ඒක දන්නවා කිව්වා.
ඔව්. එක්කෝ උසාවි ගියත් දන්නේ නැහැ සමහරවිට. මේ අනිත් අය
Sir, can I ask one question? Hello, sir. Hello, sir.
shall we
Hello, sir.
start?
Hello, sir.
You can see the sounds to the
Sorry?
students going through the
Let me check. So if I go to that one, I hope the participants, those who are attending online, is the presentation visible?
Yes, sir. We can see.
Yes, sir.
We can see, sir.
I
Sir, we
hope
can
so,
see, sir.
otherwise they will complain. Shall we start? Okay. Power of the commissioner. We have discussed this one. Commissioner of Workmen Compensation has powers of a magistrate, actually additional magistrate, for the recovery of any sum of money by way of a fine. If commissioner is not paid, if the compensation is not paid within 30 days, an additional 10% we discussed this one. The maximum, it was under the 2005 amendment, maximum for fatal accident was 550,000, but it was amended. Right now the limit is 2 million for fatal accident. Just go through quickly. Now I'm trying to discuss with you to give you some information. The amendments made to the principal enactment. Principal enactment means the ordinance, right? By Workmen's Compensation Amendments Act number 10 of 2022. What are those amendments? Major amendments. The short title, this act may be cited as the Workmen's Compensation Amendments Act number 10 of 2022. Right. Amendments of the loan title. What do you mean by loan title? Right. Loan title is this. If you go to the first slides, loan title. Just one second. Just wait for a while. Sorry. Look at this. This is the loan title. I mean the objective. An ordinance to provide for the payment of compensation to workmen who are injured in the course of their employment. In the course of their employment. Now, it has been amended. The loan title has been amended as this. It's taking time. It takes time. Okay, well, now the loan title, right? The previous one I told you, title to the Workmen Compensation Ordinance, herein after in this act referred to as the principal enactment, right, is hereby amended by the substitution, adesha karami, for the words who are injured in the course of their employment. It was in the loan title, it was like that. But now, of the words who are injured in the course of their employment, or while coming from their place of residence to the workplace, or while returning back to their workplace, place of residence, to their place of residence from the workplace, right? They are in the who are injured in the course of their employment or while coming from their place of residence to the workplace or while returning back to their place of residence from the workplace. This has been added. Now, this was a debatable, right? It was a very lengthy debate at the National Labor Advisory Council, right? Because, even though this act was enacted in 2022, 2022 Act number 10 of 2022, because the discussion, I was the Commissioner General of Labor, we had lengthy discussion with regard to this amendment. Employers actually against, right? Because it's very, very vague. When you are coming from residence to workplace and while going from the workplace to residence, something can happen. So how it could be attributed to industrial accident? That was but finally even I, because I cannot I argued. My personal opinion was it should not be, right? But however, the government wanted, and trade union were more powerful. They wanted. It was amended, right? And next amendment was amendment of Section 2 of the Principal Enactment. Section 2 of the Principal Enactment is hereby amended by the insertion immediately, right, after the definition of the expression partial disablement of the following definition. Partial disablement එක amend කරා මේ විදියට. Place of residence includes just after the partial disablement මේ ටික ඇතුළත් කරා. Place of residence includes any permanent place of residence of a workman or a boarding house or any other place where a workman resides temporarily for the purpose of coming to his workplace. This was added as a new sentence. And next, amendments of section 3 of the parcel principal enactment. Section 3 of the principal enactment is hereby amended by the substitution for the words in the course of his employment. The same thing, right? It has been repeated because there are many places where you have to, amend the place of work. The following new section is hereby inserted immediately after section 6 of the principal enactment and shall have effect as section 6A of the enactment. Section 6A එකක් කලින් තිබුණේ නැහැ. Then section 6A එකක් දැම්මා. මොකද්ද? Notwithstanding anything contained in section 6 in the course of in the case of permanent or partial disablement, the nature of employment of a workman in relation to any injury shall be taken into consideration in calculating the amount of compensation. Such compensation shall be based on the medical report issued by the relevant doctor. This clause also added as a new para to the section 6, right? Amendments of section 7 of the principal enactment. Section 7, the principal enactment, is hereby amended in subsection 1 of the section by the insertion immediately after paragraph C thereof of the following paragraph. එක D එකක් හැටියට එන්නේ. 1 එකේ තියෙනවා ABC කියලා තුනක් තියෙනවා. ඔයාලා principal enactment එක ගියාම එක පෙනේ. හරි ඒකට තව එකක් අලුතෙන් ඇතුළත් කරා D. In the case of a daily pay, this is the blunder. I'm telling you, this is wrong. Read it very carefully. This is what is there in the act. I will show you the act, right? In the case of a daily pay. So anyway, I'm not going to, explain it. Read it and understand why this is wrong. It has not been amended yet. This is wrong. But it is there in the act as it is. Right? Read it. In the case of a daily paid or piece rated workman, the monthly wage of such workman shall be monthly wage. The aggregate of earnings of daily payments or piece rates for the last 12 months during which such workman has been in service immediately preceding the accident. එදාට කලින් අවුරුද්ද ඇතුළත උපයපු daily wage ටික අවුරුද්ද ඇතුළත so piece rate has been in service immediately preceding the accident divided by the 12 and again divided by the 25. What is wrong with this?
Usually, the other laws I've seen they're taken in the last 3 months, probably.
But 12 months is no problem for this one.
But the question is whether they will be in service for a long term, like workers.
That is one thing. ඊට වඩා මෙතන there is very serious mistake.
Working days, they have divided. I mean, 12 months and 25 working days here. But that is also wrong.
That is what I'm saying.
Yeah.
Here talk about monthly salary.
Monthly.
How to calculate monthly salary, right? Yes, during the last immediate preceding year, how much the person has earned as daily wage, right? Total, and divided by 12 is a monthly,
That is very
right?
wrong.
And if you divide that one by 25, it's a daily salary. It's a daily salary. So it has not, yet been amended. So it's wrong, utter failure. I don't know, but anyway, on Commissioner to කිව්ව දවස් කීපයක් මේක amend කරන්න දාන්න කියලා. දැම්මේ නැහැ ඉතින්. Right. So this is wrong, right? but it is there in the amendment of section 11 of the principal enactment. Section 11 of the principal enactment is hereby amended in proviso to subsection 1 by the substitution for the words not exceeding an aggregate of 10,000 rupees. Rupial 10,000 මේ දඩ ගහන එකක් තියෙන, right? Of the word not exceeding an aggregate of 20,000 rupees. 10,000 was amended as 20,000. So we will finish this and we have to look at, the schedules, right? Amendment of section 16 of the principal enactment. Section 16 of the principal enactment is hereby amended in subsection 1 by the substitution of the word within 2 years of the occurrence of the accident. Right? Again, within 2 years apply කරන්න ඕන කියලා තමයි තියෙන්නේ. In principal enactment of the word within 2 years of the occurrence of the accident, or in case of death within 2 years from the date of death. Right? Date of death. This was not in the previous, the principal enactment. Again, section 18, in subsection 2 thereof, by the substitution for the word fine not exceeding 500 rupees of the words fine not exceeding 100,000 rupees. Fine, that is, right? These are the major amendments. Next, principal enactment. Imposition of surcharge on employer for the failure to pay compensation on due date. So previously it was how much? දඩයක් තිබුණානේ. How much? 10%, right? What they said, the employer who been liable to pay any sum due as compensation to workman or his hires, legal hires, as the case may be under this act, fails or default to pay that sum on or before the due date, he or she shall be liable to pay to that workman or his heirs, as the case may be, in addition to the sum due as compensation, a surcharge on that sum calculated in the following manner. Previously, it was 10%, right? But now it has A, B, C, D, E. These were not in the principal enactment. What are those? Where the payment of the compensation has been in arrears for a period not exceeding 1 month from the due date, a surcharge of 10% of the sum due has come. This was there, right? 10%. Where the payment of the compensation has been in arrears for a period exceeding 1 month but not exceeding 3 months from the due date, a surcharge of 15% of the sum due as compensation. 15. මාසයකට වඩා වැඩි, මාස 3කට වඩා අඩුයි, ඒ period ගෙවලා නැහැ. So then 15%. Then where the payment is, period exceeding 3 months but not exceeding 6 months, then the surcharge is 20%. The payment is due, right, for exceeding 6 months but not exceeding 12 months. මාස 6ක් යනකම් ගෙවන්නේ නැහැ. මාස 12ට කලින් නම් 6 ඉඳලා 12 යනකම් ගෙව්වේ නැත්තම්. So present term is 25%. Where the payment of compensation has been in arrears for a period exceeding 12 months, 1 year, from the due date, a surcharge of 30% of the sum due as compensation. These are the new amendments that you need to understand, right? Because, if you are working in a company as HR people, this is the new information. If you fail to pay within 10 months, if exceeds 10 months but not exceeds 3 months, then it becomes 15%, 20%, and 30%.
So these are replacement of Schedule 1 of the principal enactment and the replacement of Schedule 4 of the principal enactment. Section 1 and these are very important. Right? Let me now share with you my another, what is, ayyo, save, yes. And next one, let me go back to my slide. I make it buy pen and it. Just wait for a while. What is this? Where was it? What name is? Could you please ask someone to come make it cool, make a pen and then see. Not this one. I need to go to, the,
This is the word that you open, right?
yeah. No. That is not the one. Someone has to come because no. Already that is the one, right? And I can minimize, but
you can share it.
yes,
Online negative.
online.
Yeah. No. You can just minimize it.
This one, yes,
Yes.
and then raise the
Here you
online.
go here the Google.
Okay.
Oh, it's there.
It is there, but I have to share it.
Yeah, you can share the windows now. Sir.
But others, how do you say?
Yeah, you can share it. Are you in Teams or?
No. Let's see. Zoom. Let him come. මට දැන් මේකේ වෙන එකක් ෂෙයා කරගන්න ඕන. හරිද? ඒක මන් හිතනවා මේවා කරා. ඒක බලන්නකො මට මේ අර ෂෙයා කරන්න ඕන.
Zoom එකට ආයෙ log වෙන්න.
ඒ ගිහිල්ලාද? එහෙම වෙලාද?
Zoom එක අයින් කට් වෙලා.
ඒකනේ.
Zoom එකට log මම ඉන්නේ.
මේකේ join a meeting ගිහිල්ලා යන්න එපේ. sign up. minimize නෙකලේ මම. මොකද එහෙම උනේ? පරණ මැෂින් එකයි ප්‍රශ්නේ තියෙන්නේ. මම මිනිමයිස් කරේ මොනවාරි වෙලාවක. මට මේ වෙන එකක් ෂෙයා කරගන්න ඕනේ. වෙනද ඔක ඒ කියන්නේ ප්‍රසන්ටේෂන් එක නෙමෙයි. ඇක්ට් එකක් ෂෙයා කරගන්න.
ඔබ තමයි ෂෙයා කරන්න ඕනේ. දැන් ෂෙයා වුණාද නැහැ? ෂෙයා ඔප්ෂන් එකට යන්න. අල්ල. අන්න ඒක. හරිද? නෑ කමන්න නැහැ පොලිස් ස්ක්‍රීන් තිබ්බා. Okay, ෂෙයා වෙනවා නේද? හරි. So now look at the Workmen's Compensation Amendments Act number 10 of 2022. So certified on 19th of March 2022. That is the effective date. What does it mean? The date that the speaker signs, that is the effective date. So now look at, you see there are, amendments, right? All amendments are here. Not, nothing in the, the provisions in the principal enactment. Those, if the the provisions or chapters or articles have not been changed or amended, those things are not here. Those are in the principal enact. Here, what do you see? All amendments made to the principal enactment, right? What I need to share with you is this one, the schedule.
So even the schedules have changed, no?
Yes. Not schedule 3, but schedule 1 and schedule 4. Just 1 second. This is schedule 1. The list of injuries deemed to result in permanent or partial disablement, right? Just 1 second. Hello. Good. Oh, putting again the lecture again. Narayan. Schedule 1 of the principal enactment is hereby replaced and the following schedule substituted thereafter. So, list of injuries deemed to result in permanent or partial. This is the injury. And the percentage of loss of earning capacity. Percentage of loss of earning capacity. So, the permanent and in what is that pain name? Income parcel, right, of the limits or injuries resulting in being permanently, right, what is that? Bedridden. මගේ කන්නාඩිය අමාරුයි දැන් පේන්නේ නැහැ. මේවා පේන්න ඕනේ නැහැ. මේකෙත් අර බොද වෙලා වගේ මට පේන්නේ. So then 100%. Right? No, earning capacity. So it is then consider percentage the 100%. And the permanent incurable loss of mental capacity resulting in fatal incapacity to work or any other injury causing fatal incapacity to work, it is also 100%. The next one.
So here the fundamental thing in this is the ordinance is
This is act, right?
the quantum of the compensation is based not on the injury but the result of the injury.
Result of the injury, not on the injury, but result on the injury. That is important, right? So, so then next, eye injury, total loss of sight in both eyes, not only death, right? This is also 100% because you don't have any capacity to earn or work. And then likewise, a total loss of sight both eyes 100%, and total loss of sight in one eye, how much is it? 80%. Yeah, 80%. So likewise, no, it has.
Earlier it was 50%.
Yeah, earlier it was 50%. So you have to compare with both, right? Forget about the earlier one. This one is important now. Uh, the hearing injury. So you can see it. I don't need to read. And then loss of a speech. Total loss of speech. 100%. It means that, say, for example, if person cannot, the talk, it is also considered. I don't know whether, you know, it, how can it, be applied? Because, if the person is talking person, right? What do you call training people, training the staff, and then total loss of, the speech, yes, 100%. But ඇවුන්න අද පිච්චුනාමද ඒකෙමු බලන්නේ කැපැසිටිනේ right දැන් මෙත you see this right later පල්ලෙහාට යනකොට මේක ඇති නැත්තම් හොඳයි ඒක තිබුණ නැහැ කියමුකෝ ඇඟ පිච්චුනහම බලන්න ඕනේ ඒකේ ඉම්පැක්ට් එක මොකක්ද work ඔව් මා ඔව් අනිවාර්යයෙන් හැබැයි මෙහෙම එකක් තියෙනවා කණින් ගයි කෙනෙක් නෑ කියන්නේ නරක එම්ප්ලොයි කෙනෙක් නම් ඔක ඩිසිප්ලිනරි මැටර් එකක් දාලා හොස්පිටල් ලයි වෙයි ඩිසිප්ලිනරි මැටර් එකක් දානවා මොකද is negligence argue කරන්න පුළුවන් හැබැයි ඒක not fair right or in like in good faith company can pay some amount දැන් මොකද වෙලාදී මිනිහට වැඩ කරන්න බැයිද ඒක අප්පා ආම ගියා මෙහෙමයි ඕක නොගෙව ඉන්න පුළුවන් හැබැයි but not fair so lost hand injuries දැන් මේ hand injuries කිව්වහම ওই පිච්චිච් එකත් අදාළයි ඒක පිච්චිච් එක වෙනම කියන්නේ නැහැ any whatever the cause right the result hand might have been damaged එතකොට ඒක පිච්චිලාද උනේ ඩැමේජ් උනේ ඇසිඩ් වැටිලාද උණු වතුර වැටිලාද කියන එක අදාළ වෙන්නේ නැහැ what has been the result so lots of with all these the hand injuries right there are many right loss of loss of index finger right and loss of middle ring and little finger right? Likewise loss of leg. It doesn't say miscellaneous, right? There are, uh, uh, some other, it doesn't specifically mention whether it's a burn or acid or whatever it is. The result, what has been, the your leg or eye or body has been damaged, whatever the reason. Right? So this is how the percentage is calculated. And next, this one is very important. Replacement of schedule 4. You have to pay not only, just not only this one, you have to look at the schedule 1 as well. Schedule 1 and schedule 4 should be read simultaneously or observed simultaneously. One is, is a percentage of loss of earning capacity. Right? Look, the schedule 1 is this, no? What
Sir.
schedule 1 says?
Excuse me.
Say loss of speech,
Go ahead, over.
right? Total loss of speech. It's 100%. It means that the maximum has to be paid, right? If say like huh? And 2 million, but it depends on the salary. That is why you have to report schedule 4. This is, say for example, it is not 2 million, right? If the list schedule 1, what schedule 1 says, right? So this one is like, let me go back. This is what percentage of loss of earning capacity, right? Marunot is 100%. As they come 100% loss capacity. Then 100% has to be paid based on the salary structure. That is why you have to refer to schedule 4, right? Schedule 4. So say when you see the schedule 4, right? Let me go to schedule 4. This is schedule 4, right? Now let me explain. Replacement of schedule 4. Listen very carefully. Schedule 4 of the principal enactment is hereby replaced and the following schedule substituted therefore. Schedule 4. Amount of compensation payable. Amount of compensation payable. Okay. So his salary
Excuse
is
me.
less than 0 to, this is the salary range. So death of a workman, how much? Right? 1.14 million, right? Or 1100,000 and 40,000, 1100 and 40,000, 1100,000. And then permanent disablement of workman. This amount. Permanent disable. Oh. You have to, look at the definition of earning. Definition of earning. In this one, not only basic, right? The same as, the other labor legislations. Basic plus cost of living allowance or similar allowance to the cost of living. Oh. Nah. No. OT, right? Situation, right? Overtime does not attract, like EPF and ETF. This is not relevant to that. Right? Basic, this is monthly salary. Normally, basic plus cost of living, but Brava applicable, yes, right? Yes. half monthly compensation for uh, temporary disablement of workman. So the half a month kochara givano, these are the things, right? Now you understand. So 500. If say for example, the person you refer to, right? The person, right? He has something let go, whatever it is, right? Then you have to look at what is his salary range. Say it's a 20, say 30,000 to 35,000, right? And the full, if the person, death or the permanent disablement, how much? 1.4, 1.42 million. Here 1.48 million, right? Right. Now you have to look at what is the percentage. This is in case of permanent disablement or death, right? If person, lost his leg or body part of it, then you have to look at what is the percentage, 50%. So you have to pay the 50% from that amount. Yes, this is the, say for example, his salary ranges from 30,000 to 35,000, right? Salary over years. Right. Now, if the permanent disablement or death, right, there is no argument, right? This is, you have to look at it, right? And if not, no, not death, not permanently disabled, then Schedule 1 says, what is the percentage? That, මෙහෙමයි. දැන් මෙතන රේන්ජ් එක මෙහෙම හිතමුකෝ. හරිද? දැන් යමු අපි ෂෙඩියුල් 1 එකට. හරි? ෂෙඩියුල් 1 එකට යනවා. ෂෙඩියුල් 1 එකේ මේ අන්තිමට තියෙන එකක් මම ගන්නම්කෝ. right. ඔව් 120 තියෙනවා 40 තියෙනවා. right. let easy එකට යන්න. loss of middle ring and little fingers. right. ඒකත් නැතුව වෙන එකකට යන්න පොඩ්ඩක්. පේනවලු. right. Hand injuries. Loss of both hands, 100%. Right? Loss of hands or loss of thumb and 4 fingers. If the person, the person concerned, right, has lost 4 fingers, 80% from that schedule amount. එයන 1,10,000 sorry 14 ලක්ෂ ගණනක් ඇවිල්ලා තිබුණා නේද? අර කලින් එකේ ෂෙඩියුල් 4 එකේ තිබුණානේ. ඒ permanently නන්නේ. දැන් permanently නෙමෙයිනේ. ඒ permanently නෙමෙයි නම් කොච්චරක්ද lost of capacity එක බලන්නේ ෂෙඩියුල් 1 එකේ. ඉතින් 100ට කියන ගාන එවන්න ඕනේ. ඒ amount එක තියෙන්නේ permanently disabled නම් or death නම්. ෂෙඩියුල් 1 එකේ තියෙනවා 100% නම් කියන්නේ permanently disabled නම් yes 100% ගෙවන්න ඕනේ. හැබැයි ඇඟිලි හතරක් විතර යතේ ගෝල් වෙලා තියෙනවා. දැන් බොඩි එක. ඒක බලන්න ඕනේ 100ට කීයද ගෙවන්න ඕනේ. ෂෙඩියුල් 1 එකේ. percentage එක තමයි කියන්නේ. 100 මේ තියෙන්නේ 100%. ඒ කියන්නේ ෂෙඩියුල් 4 එකේ තියෙන්නේ 100% permanently disabled and death. එතකොට permanent partial fatal accident නෙමෙයි non fatal. capacity එක ඔක්කොම loss වෙලා නැහැ. loss වෙලා නැහැ කියලා බලන්නේ කොහෙන්ද? So you have to refer to schedule 1. schedule 1 එකේ තියෙනවා අත් දෙකක් කැපුණාම කීයද? කන් දෙකම හැමුණ නැතුණාම කීයද? right? ඇස් දෙකම පේන්නේ නැතුණාම 100%යි. එක හැක් නම් 180යි මගේ මතකේ. එතකොට අර schedule amount එක තියෙනවනේ. right? fatal වලට. right? නැත්නම් permanently disablement. ඒ amount එකෙන් schedule 1 එකේ කියන percentage එක ගන්න. Is it clear now?
So it's always the permanent disability sum is more than the amount that you get at death.
Sorry. Permanent.
The what do you call the compensation that you get
Yeah.
due to permanent disability is always higher than the compensation that you get when you get a death. As per the schedule.
Yes. Yes. Death is one kind, but the person permanently disabled is suffering. He's suffering his entire life. So that is why that amount is little higher than the death. එකපාර මැරලා ගියා ඉවරයි. හැබැයි අරයා so he has to live. No any source of income. Everything permanently disabled, cannot work, but has to live. It's a human being. That is why that amount, the second column is higher than the first column. One term. Okay, well, is it clear now? Right. Now we are moving to, I think, this is also, relevant to those who are attending online. My question is, you do you by yourself, right? Here is a one group, right? No, we don't have two groups. Now, look at, in my presentation, the principal, the loan title or whatever, right? The, in the principal enactment, compensation is awarded if injury or whatever happened in the course of employment. It has been amended. Right? Previously it was during work. Now, while going to work from the residence or to the workplace, so met with an accident. So it covers under this ordinance. And also, person is going back to residence or work, the place residing from the office or the workplace. During that period, the person met with an accident. That is also workplace. Workplace has the definition of the workplace or during the course of employment has been expanded. Whether it's during while working or coming to work from the residence and going back from the workplace to residence or the place where he is residing. So that is, during the course of employment means it has been broadened. Coming to work and going back. Both, right, included.
So just one question. Let's say you get the lunch hour in between, and to do some of the personal work, you go by in the bike and meet with an accident. Nothing to do with the employer, right? During the lunch break, so that also falls within this.
It depends, right? If the person gets the permission,
So lunch break, do you need to get permission?
if you are going out, you don't need. But yes, personal matter. If he is going back from work to workplace, sorry, residence place, yes, okay. But tell me, the act expanded definition does not cover what you say. You have to look at the definition. While working in the course of your employment, it can be argued, right? The lunch hour,
Say you went to buy a lunch packet. You can argue.
you can argue. But mostly the employer will not give, right? Then the person will go to the commissioner. She will decide. It's an argue. Yeah, made. Oh.
එතකොට අපිට කිව්වා වාහනේ ගියාම වා පරිස්සමෙන් දැනගන්න අවශ්‍ය මේ ලක්ෂ ටයිම් එක ගියාට ඒක ප්‍රශ්නයක් නැහැ කියන්නේ. ඔය ඇක්සස් වුණා ඒකට කැමරේ ගන්න කියලා. අනිත් එක තමයි කඩේට ගියා මේ ඒවා නෙමෙයි. ඒක තරම් යූස් කරනවා. ඒක තරම් කියන්නේ එයා මේ හරි නැත්නම් ගියාම එතන එයාගේ බයික් එක ෆුට් සයිකල්. ඒක එතනත් අපි යාට ගේට් පාස් කරන දාලා ගිහින් යාට පර්සනල් මැටර් එක දීලා ඒ තරකේ නියුනේ.
Normally, employer will not pay. Then the worker has to report to or go to the workman compensation. Then there is a case. The argument, you know, fair name අතුලට ගියාට ඔතන එන්න තර්කය තමයි advantage for the employer is, you know, the person has attended not for, you know, organizational work, not for organization. If person goes to, you know, bring something for the company, right? That's okay. Huh? Lunch break, even lunch break. If you have attended to your personal matter, then directly employer never pay. I'm telling you, never pay. Then what is next step? Report to commission. Workman compensation. Argument will take place. Finally, the workman compensation commissioner will decide to give, you know, an order. මොකද සමහරුන්ගේ මහත්තුරු කම්පැනි වෙනුවෙන් පෙනී හිටිනවා. හරි. ඒක නෑ එහෙම තියෙනවා මම ඔය දැන් ඉන්න කෙනාට කියලා තියෙනවා මේ අවුෙන්න එපා මම ඉස්සර ඉන්න කාලේ. එහෙම තියෙනවා. සමහර අයගේ කියන්නේ ඉන්නකොට මේ මහත්ය ලෝයර් සමහර කම්පැනි වෙනුවෙන් පෙනී හිටිනවා. මොකද මන් දන්නේ. මන් දන්නේ. Compensation commissioner compensation secretary ට වැඩ කරන්නේ. මන් දන්නවා. මේ පොතේ තියෙන දේ නෙමෙයි ප්‍රැක්ටිකල්. ඒරොනා පොතේ තියෙන දේට වඩා ප්‍රායෝගික සිටුේෂන් එක වෙනස්. ඒක හේතුව තමයි most of our labor legislation, employment legislations are weak. Right? There are many, you know, the enactments to address different things. When it comes to social security, in other countries, it comes under one umbrella. Compensation, EPF, whatever, you know, everything comes under one umbrella. Here we have small kingdoms. We have created small kingdoms here and there. Right. ඔයා ආගියු කරන්න හදන්නේ වාටත් මොකක් හරි එකක් වෙලක් දන්න දඬුවමක් හරි දීලාද මේ කැමයක් ගේන්න ගියා එළියට කියලා නෑනේ. ඔය වයස්ලාද පොඩි ඔෆිස් එකේම එක්ස්ටර්නල් ඒ කියන්නේ ඔයාලා ඔඩිට් කරන මං නම් එහෙම එක දන්නේ නැහැ එහෙම කොහෙවත් ලිඛිත ඔයාලගේ මොකක් හරි ක්‍රයිටීරියා එකක් වෙන්නේ නැති. හැබැයි මෙහෙම එකක් තියෙනවා. උකතන තර්කයක් තියෙනවා ඔයාලගේ බයස්ලා. රයිට්?
බයස්ලත් ඔඩිට් කරනවානේ. බයස්ලා කිව්වොත් එතන පොඩි බයස්ලා දාපු ඔඩිට් එක. පුදුම මෙහෙමයි වෙන්නේ ඕකෙන්. ඉතින් අරලා තියන්න ඔය ඉතින් ඕකට තියෙන්නේ එක්ක කැන්ටිමක් තියෙන්න ඕන. ඒ තමයි ෆැසිලිටිස්. හරි. ඔව් ඒක තමයි. එහෙනම් එයාලට කෑම ගන්න තැනක් හදන්න ඕන. රයිට්. ස්මෝක් කරනවා නම් ඒවට වෙනම ප්ලේස් එකක් තියෙන්න ඕනේ. රයිට්. ඒක තමයි. සෝ එතකොට ඒකයි කිව්වේ ප්‍රැක්ටිකල් මේ පොතේ තියෙන දේවල් වලට වඩා ප්‍රැක්ටිකල් වෙනස්. දැන් ඔන්ලයින් ඉන්න අය තනියම මේක කරන්න මගේ so what I'm proposing is you have to I show you that in my previous presentation the workplace or the course of employment I mean the work the in the course of employment injury in the course of employment the course of employment has been the definition has been widened, right? Not only in the course of employment but also while coming to work from workplace residence and going back from workplace to residence. During that period any incidents, accidents or whatever, right, took place, that is also covered by the Workmen Compensation Ordinance as per the new act. Whether it is correct or wrong, right, is justifiable. You have to justify and make certain the points, right, and argue on that point. So that is please metana quality ka diyena, please start. So that is it's exercise is required because then you learn many things because the sharing the information. Please can you take this one? Online ඉන්න අයත් මේකට සම්බන්ධ වෙන්න. කවුරු online කතා කරන්නෙත් නැහැ ඉතින්. දැන් 2යි වෙලාව.
ඔව් සර් කියන්න.
So my question once again is, so give me the what do you call this one? Right, amendments of the section 3 of the principal enactment. Section 3 of the principal enactment is hereby amended by the substitution for the words in the course of his employment of the words in the course of his employment by an in the course of in the course of his or her employment by an accident took place while coming from his place of residence to the workplace or while returning back to his place of residence from the workplace. So this has been, section 3 has been broadened, right, amended. Section 3 in the principal enactment, it was accident or whatever, right, in the course of his employment. Now not only in the course of accident or disease, in the course of his or her employment, but now not only in the course of employment but also coming to work and going back from work to residence place. During that period any accident took place, it is also covered by this ordinance, whether it is justifiable. Please just I think those who are attending online, you also do yourself. I'm going to ask.
සර්
කැමති විදියකට තියාගන්න පුළුවන්. මේ ඔන්ලයින් මේ දෙක වුණාම හරි කරදරයි. මොකද ඔන්ලයින් ඉන්න අයට මේකක් දෙන්න බැහැනේ මොනවද මේ.
සර් excuse me.
අපි points 4 and against දෙකම දාමු.
ඔව්.
හා? පැත්ත බලලා weight backing weight එක කියන එක තමයි.
No, ඒක හරි කියලා පොයින්ට් එකක් දාමු. ඒක වාට තුනෝ පුළුවන්. ඔව් කියන්නේ හරි එකක් කියන්නේ.
ජීවන් නැහැ කියලා කිව්වොත් ඉවරයි.
නෑ මේකයි ඒකේ තියෙනවා දැන් on the way to work and after work අනිත් countries වල දැන් public transport එක ඇත්තටම really matters. දැන් ශ්‍රී ලංකාවේ ගෝවා city private bus එකේ ගියා නම් ඌගීලා හැප්පුවොත් ඒක වාගේ වැරද්ද නිසා නෙවෙයි වැඩට ඇවිල්ලා නෑනේ අනිවාර්යෙන් you should be covered.
එක point එකක් වෙන්න ඕන ඔය කියනවා වගේ as long as he is not negligent.
idea. ඒක නම් මුල
හෙල්මට් දාන්න ගිහිල්ලා මොනවා හරි ගිහිල්ලා
මම දෙන්න බෑ තමයි ඇඟිලි එකතු කරන එක.
අඟුලි බල. Right, that's why we present kare, you know, our presentation skills on that.
presentation में लिखिए
How many did recording है?
आपकी वाला yeah
Your side picture. Where you were? Okay. Copy a degree program. Sunshine Home. Oh, then I then he must right. Then actually I have done my LPs and final apprentice here. Among them, make it put a special grant on itself.
Again, on the employment law.
Yeah.
අපිට කතා කරන්න විතරයි දැන් presentation
නෑ ඒක නෙවෙයි.
No, කරන්න ඒක අපි ඇත්තම කවර් කරන්න ඕනේ නේද? ඕනේ.
දැන් අපි දැන් මේ යන්නේ yes කියන එකකට යන්නේ. yes කියන්නේ අපේ දැන් මේකනෝගේ ලංකාව ගත්තොත් අපේ public transport system එක අද නැහැ ඒක අපිට නැහැ ඒකින්ද accident ගණන් වෙන්න පුළුවන් which is beyond the control of the
employee.
ඔය අනිත් තමයි
ඔයාගේ වැඩේ ඔයා නිකම්ම ගෙදර ඉන්න නිසා මෙතන යනකොට ඔයාට ඕකේ. ඔයා මේකම කොළඹ ඔෆිස් එකට මේ ප්‍රයිවට් බස් එක හරි මේ ට්‍රේන් එක හරි ඇවිල්ලා ආවොත් ඔයාට උදේට ඉඳගෙන ඉඳගෙන යනකොට සීට් ඔයා ට්‍රේන් එක ඇවිල්ලා එන්නේ ඊදින එක ඇඳුම් ටික උදේ අරගෙන ඇඳුම් වයිට් ෂර්ට් එක නෙවෙයි ඒගොල්ලෝ ඔෆිස් එකට එනකොට එන්නේ.
So transport system is up. I mean, the idea is
The company is also not providing transport. They are just paying you the allowance. ඒ නිසා සමහර වෙලාවට ඉන්ඩෝනෙසියාවේ we set up to the southern bus. ඔයාට ඕන නම් ඉඳලා ලෙජර් එන්නත් පුළුවන් නිකන් ඉන්න බස් එක. ඒ වුණාට ඔව් ඇඟිල්ල තියන්න ඕන නිසා අපි හම්බෙන ට්‍රාන්ස්පෝර්ට් එක නැගලා එනවා.
no, that's reality, no? Yeah.
8:30 start කරන්න ඕන නම් අනිවාර්යෙන් ඉන්න බස් එකේ ඉන්න ඔයාට ඕන බස් එකේ ඉන්න බෑනේ. ඒක ඔයා යන්නේ ඔයා නිකම් විතර ළඟ
going back to home.
ඔය දෙපැත්ත.
proper public transport and I think mention කළේ ඒක.
අනිත් එක එයා කිව් එකේම අමාරු වෙනවා කියන්නේ beyond your control. actually that වෙන්න පුළුවන්.
එහෙම වැඩ දෙන්න දෙයක් ඉතින් ඉඳලා තිබුණේ ඒ ඇක්සිඩන්ට් එකක් වෙන්නේ නැහැ. because of employment only
public transport දැන් අතන මේක කාලේදී මතකද වැටෙන්න බැරුණා. ඉන්න පස්සේ expansion එක සාධාරණයි. ඒක කරන්න ඕනේ.
දැන් අපි කියමු ඒ ඇවිල්ලා 7:30 යා පටන් ගන්නවා නම් බැලට එන්න at that time onwards it should be calculated. මොකද ඒක එන්න ඕන නැත්නම් ඒ වෙලාවට ගෙදර ඉන්න පුළුවන්
He's coming for the work.
work only for the purpose of his work and it is not for his own benefit. ඒකත් ආපු එක ඔෆිස් එකෙම ඉන්න බෑනේ වගේ හදින්න නැහැ නේද?
He's coming for the work for organization. Organization. Yeah.
ඕගනයිසේෂන් එකේ වැඩ කරන්න තමයි perform කරන්න තමයි purpose එක. purpose එක.
No, his intention to be on time to work, or you can say his intention of traveling is for the purpose of the
ඔකොට ඉන්ටෙන්ෂන් එක මේ ඉදිනම් එන්නේ නැහැ. ඉදිනම් අපි දෙන්නේ අදිනේ ඔය අපි කොහොම කරගන්නේ සාමාන්‍ය ප්‍රැක්ටිකලි.
මට එන්නකොටත් අපි වැඩට එන්නකම් කියන්න බෑනේ එයා එනවා කියලා. ඒක අපි next ඊළඟ no කියන එකට අපිට ඒ arguments ටික ගේන්න පුළුවන්. Up until he arrived the office, you never know he's coming to the office or not.
I think no කියන එක දාගන්න පටන් නෑ නෑ ඔතන නෙවෙයි යට ස්පේස් එකක් කියලා
For their personal
apart from the employment, there can be other reasons. For private reasons කියන්න පුළුවන් නේ. ඒගොල්ලන්ට අපතෙන් ඒක හින්දා ඒක පුදුමයක් එකක් වුණොත් ඒක ඇත්තටම සාධාරණ නෑ නේද කියන්නේ. ඇත්තට ඒක
because under the influence of liquor. Under the influence of liquor නම් මේක ඇත්තටම ඒක යගේ personal මේක so ඒක වෙන්න පුළුවන්. අනිත් එක අපි කියමු safety precautions ගන්න පුළුවන් without that. Or taking precautions that negligent act කියලා දැම්මොත් personal meetings afterwards. Friends. අපි කිව්ව ඔයාට උනා කියලා we say afterwards.
අපිට උනා ඒ කේස් එක.
නෑ ඔයාට උනා කියන්නේ මම ආන්නේ මම personally for me and for you.
බලන්න හැබැයි ගාදියෙන් වෙලා තියෙනවා. කේස් ස්ටඩීස් එක නෙමෙයි. ෆැක්ටර් එකක් නෙමෙයි. දැන් අපේ උනා උඩන් පහට ඔක්කොම සෙට් එක ඔෆ් කරලා ගෙදර යනවා කියනවා අපිට කෝල් එකක් ආවා අන්තිමට එක්ස්චේන්ජ් වෙලා මේවයි. ඒක ඔෆ් හරි. උතර මු යන ගමන් අර වාක්‍ය වල ගෙදරට බඩු කරගෙන ළමයාගේ වැඩක් කරගෙන යනවා. පාන්දුව කරන එක්ස්චේන්ජ් එක ගලා තියෙනවා. එතකොට අපි කිව්වේ ඒක යා ඩිරෙක්ට් හවුල් එකේ ගිහලා තියෙනවා. එතන යාගේ පවුල් පිළිගන්නත් කරගෙන ආරාම යනවා තමයි ගෙදරට ගිහලා තියෙනවා. එතන අපි ඒක සාර්ථක කරුවා. යාගේ පවුල් පිළිවෙල කියන්නේ යා වන්සු ඩිරෙක්ට් ගියා නම් ප්‍රශ්නයක් නැහැ අපි ඒක ගෙවන්න ඕනේ. එක්ක බේස් කරගෙන. යා දැන් පවුල් පිළිගන්නත් කරගෙන ගිහලා තියෙනවා. එතකොට ඒක අපි ගෙවන්න ගිහුනේ. ඒක ගෙවන්න.
හරි ඒක ඒක ඒකට මොනිටරින් කරනකොට එයාගේ ඔක්කොම රෝඩ් එක යාව සාමාන්‍යයෙන්
අර දැරුවේ නෑ පොරේ. පොඩ්ඩක් පස්සේ එතකොට දැන් අපි බැලුවේ මුලින්ම මෙෂර් කරේ එයා ඉන්නේ ඒක අපි මැනේජර් කෙනෙක් කන්සිඩර් කරලා එයාව ගන්න. එයා ගෙවන්න ඉන්න. එයා ගෙදර ඉඳන් ඉන්න නෝමලි කොච්චර කාවක් යනවා. හරිද? ඒ වගේ ඕෆ් කරලා කොච්චර කාවක් යනවා. ඒක මෙෂර් කරලා. කරලා දැන් එයා පාන්දුරට ගිහලා තියෙන්නේ නෝමලි පාන්දුරට වගේ කොච්චර කාවක් යනවාද? එයාට කොච්චර කාවක් ගිහලා දෙනවා. මූ කිව්වේ මොන ගෙදින්ම ගෙදරට ගමන් තමයි හිතේ කියලා. නැහැ නැගිටින්න දැන් අපිට ඒක මෙෂර් කරන්න පුළුවන්. අපි බස් ස්ටොප් එකකට ගත්ත Google Maps එක කන්සිඩර් කරා. Maps එකේ දාලා දැම්ම එතකොට ඒක ඩිරෙක්ට් යන කොච්චර කියලා කියන්න බලන්න. ඊට නෝමලි එම්ප්ලොයි කෙනෙක් කොච්චර කාලක් යනවා කියලා. ඒක බලලා ඊට පස්සේ මෙයාට කොච්චර කාලක් කියලා දෙනවා. ඒක මෙයාට ඊට වඩා වැඩිපුර කියලා දෙනවා. දැන් මෙයා බුලේ කියනවා මං කෙලින්ම ගෙදරට ගමන් තමයි හිටියේ. අන්න ගන්න ඕනේ ඒක මොනවද? අයිකෝ ටැක්සිලට එකයි තමයි ඒ ගැප් එක කොහොමද කියලා ඒක කන්සිඩර් කරලා නාගේ නේද? දැන් මෙයා කිව්ව මම මුකුත් කරේ නැහැ ගෙදරදී කෙලින්ම ගෙදරට ගමන් තමයි හිටියේ ගෙදරට ගමන්. ඉතින් කම්පියුටර් යාදදී ඒක චෙක් කරනවා අපේ යාද වැඩ ගන්න කපුලක් පැතිරෙන්න ගත්තා වැඩ ගන්න කම්පියුටර් වැඩ ගන්න බැහැ මැෂින් එකේ තියා දුන්නේ වැඩ දාන මාසේ අර ඔපරේටර් මැෂින් එකට නෙමෙයි දුන්නේ තමයි එන ස්කූල් එකේ අර යාළුවන් තමයි වැඩ කිව්වේ ඒක ප්‍රශ්න තමයි කියවන්න තමයි ඒගොල්ලෝ ගත්තේ සල්ලි වෙනවා කරලා ගන්න ඕනේ කියලා මේ කල්පනා කරනවා කැඩි නැත්නම් ඒගොල්ලෝ කිව්වොත් එහෙනම් මම මෙච්චර ගෙදර ඇතුල් එකකට අල්ලාගෙන එක්කම ගෙවන්න ඕනේ. අපේ කිසිම වෙන්නේ ගෙවන්න. මම ඕස්ටෝපේ ගමන කරනවා. දැන් වාහිතන් ලංකාවේ තියෙන දිස්ත්‍රික්ක 24. පළාත් 1000 ගණන් තියෙනවා. දිස්ත්‍රික්ක එක ගම එක නම් ස්ටෝපේ ලියන්න බෑ.
Case by case.
මොකද මේක අනිවාර්ය ලෝකයේ තියෙනවා.
ඒ පාර යනවා.
යන්නේ ගුඩ වෙනවත්
එතකොට ඔප්ෂන් දෙකක් ගන්න වෙනවා කියන්නේ. මොකක් හරි කියන්නේ.
නෑ නෑ පර්සනල් out of the way ගිහිල්ලා පර්සනල් ගන්න බෑ කියලා කියනවා. තමයි යන පාරේම. හරි එතන තියෙන එකකට ගිහින් යන්න පුළුවන් ඒක ප්‍රශ්නයක් නෙමෙයි. අපේ තමයි මේ මෙතන ගිහලා ඒක මේ ඉන්ටර්වියු එකේ කන්සිඩර් කරනවා ටයිම් එක තමයි කන්සිඩර් කරනවා. අපේ පර්සනල් එකක් නැහැ. එතන අපේ මේක දුර නෑ මොන මෙන්නමයි
ඒක කොච්චර ඩිෆරන්ට් එකක් තිබුණා ටයිමින්
තිබ්බා පැයක කැප් එකක් තිබ්බා. ඔන්න මම කියන්නේ ටයිමින් විතර කොතන ගත්තේ අසාධාරණ වෙන ඔප්ෂන් එකක් නෑ. අපි ඉඳලා යනවා. අපි ඉඳලා යද්දී අපි යන නෝමල් පාර් හයිවල් පාරට යනවා. ඒකේ අපිට එතන තියෙන අපි කඩේ තියෙන අපිට යට ගොල්ල පුස්තක පාරුවා. අපි මොකක්ද අපි අවුරුද්දේ ගිහිල්ලා මේ තව කොහරි අපොයින්ට්මන්ට් එකක් දාලා එතනත් ගිහිල්ලා එනවා නෑ ඒක නේ යාට අපි ආයතනයක් පැත්තෙන් තමයි කියන්නේ ඔයා මෙතනදී වෙන ගමන් ගිහිල්ලා තියෙන එක තමයි ඔයා දෙන්නේ මෙයාම කරන්නේ යන පැත්තෙන් එයා shopping එකේ බිල් ඉස්සරහට යනවා දැන් එයා කැමරාවක් තියලා ඉස්සරහට කරා ඒ ඉස්සරහට ලියන්නේ නෙමෙයි ඉස්සරහට කැමරාවක් තියලා
public transport accident
public transport එක accident එකක් වුණොත් ඒක notice කරනවා. මේක තමයි ඕන් වෙහිකල් එක public transport
ඕන් වෙහිකල්
ඔව් public transport එකේ accident එකක් කළාම අපේ යා disable නැත්නම් අපි අනිවාර්යෙන් සල්ලිවල ගෙවන්න ඕනේ compensation එක ගන්න.
නෑ මම අහන්නේ දැන් එයා ගියේ හැවිලා public transport ඕන් වෙහිකල්
ඕන් වෙහිකල්
මොඩල් බයික්
නෑ හැබැයි ඔය transport service එකේ ඒකට යවන්න. උදාහරණයක් මම කියන්නේ transport practically ඒක හරි අද හැමතැනටම ගිහිල්ලා ආයෙ ගිහිල්ලා ඒ වගේ ඉස්සෙල්ලා ආවොත් අපි ගන්න ඕනේ. දැන් transport facility
ඒක එකක් හරි හරිද දැන් අපි ඕන හරි ලෝයි කියන ගියාට සෙට් කරලා නැද්ද දන්නේ අපි කියමුකෝ දැන් ඉන්න එයා මෝටර් බයික් එකේ ආවේ උල වැඩ කරන්නේ එයාට උනන් එදා ඉන්න තුන්දෙනෙක් ඉන්නවා එයාගේ පර්සනල් ටික එයා ඒක කලින් ඉවර කරනවානේ හරිද දැන් මේක වැඩට ආපු නිසා මේ වෙන කවුරුද යාට ගෙදර ගිහිල්ලා කැම් ගෙනිල්ලා දෙන්නේ නැහැනේ ඔරෙන්ජ් අපි කියමුකෝ මොන ග්‍රෝසරි හරි ගන්නවා නම් එයාමනේ ගාගෙන යන්න ඕනේ යන ගම වෙන වැඩක් නෙවෙයි දැන් එයා මේකට මොකද ජොබ් එක ඇවිල්ලා තිබ්බේ නැත්නම් ඒ ඉන්සිඩන්ට් එක වෙන්නේ නැහැ නේද
ඔයා කියන්නේ එයාගේ වලට වෙනම කරගන්න ඕන ඒක වෙනම කරගන්න ඉන්නේ එහෙම කරගත්තොත් තමයි ඇක්චුලි වෙන්නේ නැහැ ඒක හරි
ඔන්ලයින් අය අයින් වෙන්න එපා ඕමම ඉන්න ලොග් වෙලාම ඉන්න මොකද there is a presentation right අපේ මේ group එක the group will make a presentation with regard to what you call this the definition
කියන්න ඕනේ නැහැ යාට ඇක්සිඩන්ට් එක වෙන්නේ නැහැ
shall we just come here and tell I mean individually right your views because the online people are also waiting here so better some of you we don't need to have the everyone but if possible yes okay I'm okay with that and the views in this regard because you are you all are working right practical you have met with lot of practical experience right you are having practical experience so sharing those information and what will happen how do we define this the problem here is not not only in the course of employment right while coming to work from the workplace or residence it covers if the person met with an accident and while going from work to residence also if accident person met with an accident compensation has to be paid as per the new amendment so how is it possible right say for example there are the argument if the person like you said many things, right? Now Lankawe may baskaru යන විදිහට even public transport, and so people met with accident. So then if the situation is very worst, right, as far as the transportation is concerned, there is a the gravity for accidents will be high. So in such a situation, should the employer be penalized? Or on the other side, a genuine worker, or loyal worker, and working up to 5 or whatever, and go to residence place, met with an accident. So if the person lost his earning capacity 100%, so then if who is the liable? Right? Employer is liable to pay. That is a cost to the company. And also, if there is no payment system or whatever the insurance system for them, the worker, out of the the workplace, so then how the person can live his entire life? What about the dependent? This is an argument. So finally, you might then finally I will tell my opinion. I mean, nothing. What we need is an insurance.
Hello, sir.
Not only employer, whatever, the money has to be pooled. Definition, let it be, right? Take some percentage. It's like per person from the payroll, it's around 0.04 or something like that, 0.06, something like that, has to be contributed to a fund and establish an insurance system. Otherwise, look at lot of argument, lot of cases will be created with this definition, and then it's dragging. Only one or two commissioners, they are supposed to investigate everything. So cost to the society, right? It's cost to the society. Okay, right. Can somebody just because other people are also waiting
Hello,
here.
sir.
I
Hello,
think
sir.
you have two, all of you have practical experience.
Hello, sir.
You have
Hello, sir.
different view always, right?
Hello, sir.
Right. Why
Hello,
don't you
sir.
just come here and
No,
to the mic,
the
not
voice is
mic,
not going through.
the camera. Then the
Yeah,
other
yeah,
will
sure.
also see.
I also tried to
Why?
speak twice.
You are forward,
It's not
right?
going through.
What to do?
Forward
We have to keep
lady.
our mouth shut.
What is the task to
Whatever
do?
comes to you.
No, as per the
Now
amendment,
the
workplace
online,
has
right,
been
people, online participant, what you need to understand is
amended.
earlier compensation has to be paid for a worker met with an accident or disease in the course of employment. වැඩ කරන අතරේ. Then වැඩ කරන අතරේ විතරක්
මොනවද
නෙමෙයි.
කරන්න ඕනේ කියලා තේරෙන්නේ නැහැ.
වැඩ පොලේ
නෑ මේක
ඉඳලා
කර
ගෙදර
මේක
යනකොට
කරන්න
ඇක්සිඩන්ට්
කියන්නේ
එකක්
අර
වුණා.
ගෙදර යනකොට
ගෙදර ඉඳලා
ඇක්සිඩන්ට් එකක්
වැඩට
වුණත් ගෙදර
එනකොට
එනවා
ඇක්සිඩන්ට්
වැඩකට
එකක් වුණා.
ඇක්සිඩන්ට් එකක් වුණත් ඒක
ගෙවන්න
ගෙවන එක
ඕනේ.
සාධාරණද නැද්ද කියලා.
Definition එක පළල්
ඒකද
කරනවා.
සාධාරණ
So what are the
උත්තරේද ඕනේ?
consequences?
ඉච්චරයි.
ඒක
That's
තමයි
why
ඉච්චර.
what I'm asking. What are the consequences?
Hello, sir.
And then what would be
ඉතින්
the options?
ටෙක්ස්ට් මෙසේජ් එකක් දාන්න
please,
group එකේ.
mic එක මේ වල තියෙන. එතන ඉල්ල කි. නෑ
Hello, sir.
ඇහින් හයියෙන් කියන්න මොකද? So online අයත් ඉන්නවනේ.
group එකේ දාන්න මේ ඇහෙන්නේ නැහැ කියලා.
Should pay the compensation.
මේ අපි කියන දේ.
Plus,
මම දැම්ම ඒක response නැහැ.
a worker is coming to the company, the pure intention is reporting to work. So sometimes it will be a direct reporting to work, sometimes through other ways.
A little bit louder, please.
Through other ways, they'll report to work. Anyhow, one time they'll report to work. Or within 1 or 2 hours, they will report to work. With late hours, so anyway, the pure intention is reporting to work, and I say that they should pay because if the company has provided a company transport, that injury wouldn't be happening. So the employee will be protected. As the company has not given a transport in that route, the employee have to come through their own vehicle, so he or she might be get injured. And the other thing is, should pay means if the employee should, when the injury has happened, they should be admitted to hospital. They should be hospitalized. If not, no.
Good point. Yeah.
Because we have no other options to say that how much the injury is.
Just one second. Oh. ඇහෙන්නේ නැහැ. මේකේ මයික් එකකට කතා කරොත් ඇහෙයිද නෑ?
ඒගොල්ලෝ කතා කරන්නේ නැහැ.
අපිට ඇහුන්නේ නැහැ.
මේ මියුට් කරලා දාන්න.
උදේ ඉඳලම කතා කරනවා බලන්න. උදේ ඉඳලා කතා කරනවා. උදේ ඉඳලා ඇහෙන්නේ නැහැ කිව්වද? ඔව්. මට ඇහෙන්නේ නැහැ. අපි මේ group work එකක් කරන්නේ මේ presentation.
Hello, sir.
hello 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 ඇහෙනවද
ඔය දෙකෙන් එකක් දෙන්න.
hello
ලලිත් මිස්ටර් ලලිත්ගේ විතර.
ඇයි මේකෙන් මගෙන් අහන්නේ මොකද?
නෑ යා හැමදාම මිස්ටර් ලලිත් අහමද්
ඒක ස්පීකර් එක වොලියුම් එක වැඩි කරලා පල්ලෙහාට.
Hello, sir.
කාට හරි anybody කාට හරි උමනයිද කතා කරන්න? hello
Sir,
hello
can I?
sir අපි කතා කරන එක ඇහෙන්නේ නැහැ සර් ඔයගලන්ට
ඒ තමයි මට ඔයාලා කියන එක මේකට ඇහෙන්නේ නැහැ.
ඒක තමයි
Hello,
මම හිතුවේ. කලින් ඉඳලම කතා කරනවා සර්ට ඇහෙන්නේ නැහැ. තව එක්කෙනෙකුත් ඉන්නවා. කතා කරන්න. තර මොනවයි යාගේ ලැප් එකේ මොනවයි ස්පීකරේ අවුලක් වෙන්නේ නැති.
අපි උදේ ඉඳන් කතා කළා කියලා.
ඇහෙන්නේ නැහැ කියනවා. සද්ද වෙලා තියෙනවා. ඉස්සෙල්ල නෙවෙයිනේ දැන්නේ. උදේ ඉඳලා දැන් කතා කරන්න බලන්න.
ඇහෙනවද?
yes now it is okay.
ඕකේ. අපි සර්ගේ ලෙක්චර් එක අපිට ඇහෙනවා. අපි කතා කරන එක සර්ට ඇහෙන්නේ නැහැ මං
ඔව්
හිතන්නේ.
මෙච්චර වෙලා උදේ ඉඳලම ඇහුන්නේ නැද්ද?
ඔව් මම ස්ක්‍රීන් එකක් ෂෙයා කරන එකත් සර් අර ඇමන් ඇක්ට් එක ඒකත් අපිට ෂෙයා වුණා. ඒක තමයි මං ටෙක්ස්ට් එකක් දැම්මේ සර්ට.
ඒක ෂෙයා වෙලා නැද්ද?
ඔව් අර ස්ක්‍රෝල් ඩවුන් කරනකොට ඒක අපිට එන්නේ
ඔව් දැම්මනේ අර schedule 1 schedule 4
ඒක මොකුත් නෑ අපි දැක්කේම නෑ ඒක. ඊට පස්සේ සර්ට
පොඩ්ඩකින්
අපි උදේ ඉඳන් සර්ට කතා කළා.
මට එකක්වත් ඇහුන්නේ නැහැ උදේ ඉඳලා.
ඒකනේ අපි කියන්නේ ෆිසිකල් එන්නේ කියලා. ඇහුවේ නැහැ.
ටිකට් එකක් යවන්න අපි එන්න.
දැන් පේනවද?
ඔව් සර් දැන් එනවා. දැන් පේනවා.
හරි. මේකේ බලන්න තියෙන්නේ just wait මේකේ ඕගොල්ලෝ බලන්න ඕනේ right මේකේ අර presentation එක හරිනේ ඒක පැහැදිලි වුණා නේද presentation එක දැක්කනේ මේකේ බලන්න ඕනේ මේකේ schedule 1 කියලා තියෙනවා එකක් හරිද hello
ඔව්
schedule 1 කියලා තියෙනවා එකක් ඒකයි schedule 4 කියන එකයි තමයි බලන්න ඕනේ right you have to refer to schedule 1 and schedule 4 schedule 1 talks about මේ තියෙන්නේ schedule 1 එක හරිද මෙතන කියනවා schedule 1 list of injuries deemed to result in permanent partial disablement හරිද එතකොට permanent and right ඒ කියන්නේ permanent disability එකක් නම් death එකක් නම් එයාගේ capacity එක lost වෙනවා by 100% හරිද eye injury එකක් වුණොත් as දෙකම total loss of sight in both eyes එතකොට එයාගේ define කරලා තියෙනවා මොකද්ද lost
percentage of loss of earning capacity 100%. Have total loss of sight in one eye. එක ඇහක් විතරක් අහිමි වුණොත් capacity එක loss වෙනවා කොච්චරකින්ද? 80% වලින්. Hearing injuries, total loss of hearing 80%. ඒ කියන්නේ capacity එක loss වෙනවා. ඊට පස්සේ total loss of hearing in one ear, right? 50%. ඒ වගේ ඊට පස්සේ බලන්න ඕනේ. So are you listening? ඇහෙනව නේද?
Yes, sir. ඔව් sir.
ඊට පස්සේ බලන්න ඕන schedule 4 එකට ගිහිල්ලා. හරි? මේ තියෙන schedule 4 එක please. schedule 4 එකට ගිහිල්ලා. මේ පළවෙනි column එකේ තියෙන්නේ monthly wages of the workman injured. monthly wage එක මේ range එකේ වැටෙනවා නම් death එකකදී ගෙවන්න ඕන ගාණ මෙතන තියෙනවා. death එකකදී ගෙවන්න ඕන ගාණ කියන්නේ 100% capacity lost. permanent disablement එකේදී ගෙවන්න ඕන ගාණ මේ column එකේ තියෙනවා. මේ salary එකත් එක්ක බලන්න ඕන. salary range එක මේක. යනවා permanently 100% lost වෙනවා නම් earning capacity මේ තියෙන column වල තියෙනවා ගෙවන්නලු. හරිද? හැබැයි 100% lost වෙන්නේ නැතුව එක ඇහක් අහිමි වුණොත් හිතන්න 50% තමයි lost වෙනවා කියලා schedule 3 එකේ තියෙන්නේ. එතකොට එයාගේ salary range එක අපි හිතමු 30000යි 35000යි අතර කියමු මේ range එක. එතකොට එයාට permanently එයා disable නැහැ. permanently කියන්නේ death වුණොත් මෙච්චරයි permanently disable වුණොත් මේ ගාන. ඒ 100% loss එක. එහෙනම් එක හැක් නැති වුණොත් වෙන්නේ 50% loss එකක්. එතකොට මේ කියන ගණන් වලින් මැරෙන්නේ නැහනේ. එහෙනම් මැටෙන්නේ මේ කොලම් එකටනේ හතරවෙනි කොලම් එකටනේ. ඒ කියන්නේ permanently disable කියන එකටනේ. ඒකට අදාළ මුදල තියෙනවානේ 30000යි 35000යි අතර salary range එකක් තියෙන කෙනෙකුට 1570000ක් තමයි මූල්‍ය වන්දිය හිමි වෙන්නේ. හැබැයි යාගේ ඒ total 100% lost වුණා. හැබැයි තනි හැක් නැති වුණාම schedule 3 එකේ schedule 1 එකේ කියනවා only 50% has the person has lost only 50%. එතකොට ගෙවන්න ඕනේ මෙන්න මෙතන තියෙන 1570000 කියන එකෙන් 150 විතරයි. right? ඒ විදිහට බලන්න ඕන capacity එක lost වෙච්ච ප්‍රමාණය කොච්චර. is it clear? දැන් පැහැදිලිද?
ඔව් sir.
හරි. අයියෙන් කියන්න මටත් කියන එක ඇහෙන්නේ නැහැ සමහර අය.
ඔව් sir. ඔව් sir.
our sorry, the lady who is having different idea, please loud, right? You talk, listen, right? One by one, because of the definition has now changed. No, the people have, whether it is correct or wrong, right? There are arguments in favor of workers, in favor of, now with this definition, expanded definition, worker are more favorable. Worker, because not only වැඩ කරන වෙලාව විතරක් නෙමෙයි වැඩ ඉවර වෙලා ගෙදර යනකොට ඇක්සිඩන්ට් එකක් වුණා, the worker, the compensation has to be paid according to schedule 1 and schedule 4, right? Looking at the schedule 1 and schedule 4, right? While ගෙදර ඉඳලා, while coming to work from the workplace, residence or home, it is also met with an accident, the person will be covered by this act. Is it justifiable, right? Some people have different opinions, even in the sense, some people are in favor of workers, they have argument. Some people may be in favor of worker, employer, they also may have some different opinion on that. So listen very carefully, right?
So as soon as the injury
yes.
in the cause of injury, for sure that employee should get hospitalized, or else in favor of the employer I speak that they should not pay, because the employer doesn't know where, when, which date. They have no idea, because here in Sri Lanka people can make amendments. So for sure the employer should pay the compensation if according to a medical report which the worker has been hospitalized, or else no need. So for sure, even no,
compensation එක කියන එක වෙනයි. එතකොට එතනදී ආගේ ඒ සම්බන්ධකයි ඒක කියන්නේ සිටුේෂන් දෙකක් නේ.
no.
Later,
So even to dress the wound, they have to go to a general hospital, not to a private sector hospital. From the favor of the employer, I say. With that thing, the doctor will prescribe whether he should be hospitalized or should the wound be dressed or not. So with that document, they can go to the employer and submit and take the compensation. Or else, I guess the employer doesn't want to pay because the employer have no idea whether the employee has got injured while coming to work or not. So after going home, because every person has their personal matters, the employer should pay because he has completed 9 hours of working and everybody has personal matters. So they have worked in the company, and so employer is liable to pay because people can go anywhere. Employer is liable to pay the compensation because everybody has personal issues and personal matters, so they have to attend because almost they have completed their task. So anyhow,
Hello? Any question? Okay, please.
so
go ahead.
anyhow, as the person has completed their task, the employee is liable to pay. That's what I say. No matter where he goes, but in if in usage of liquor or something, there might be issues. If it is checked, so even in that case, the employee will be hospitalized because injury, no. So with that, employee will have issues, but still the employee is liable to pay for any employer who will be going to home after work because he have completed his task at office almost.
Okay, right. But
Thank
is, in summary, what he said is because the person has intention to come to work when coming to work from the residence, and also on the other side, the worker has worked 9 hours continuously and contributed to the company. Right? He or she is going back to his residence, the work place of residence, met with an accident. It is also responsibility of the employer if company does not provide transportation. That is your argument. But what you are saying is, one important thing. See, highlighted is, definitely the person, if the person met with an accident, definitely should go to hospital, right? National hospitals or government or public hospitals, not for, Ayurvedic or private hospitals, right? So then the doctors, because, this still our hospital system, the public health, this is still okay in the country. So they will determine whether it's a major one or how many days, how many months the person has to rest. So everything will be determined, right? So therefore, what he has observed, see in the every group or the group, everyone in the group, it's a very important thing, right? So anything else?
I have different opinions.
Yeah, please come because others
Uh,
listening.
the first question I would ask her: why only private national hospital? Why not private hospital? Or we'll say I'm just asking an example because we have our Lanka hospital here, Azri here, and we have almost 3 private hospitals here, right? All the hospitals are managed by proper doctors who are working on the government sector. One first question, and if the accident happens here, and if it takes another 1 hour to reach national hospital, sometimes with the traffic. So still you want him to go and admit to the national hospital or the closest hospital, Lanka hospital or Rasi? The ambulance, you have to wait for the ambulance also to come and pick you up, right? Yeah. No, I'm just asking an example. If you have the access to the closest private hospital, within 5 minutes you can reach to the hospital.
You can reach the private hospital, but for medications you have to go to the general hospital because I don't.
Why all the companies are giving insurance to the private hospital, not to the national hospital? Our company, we pay to the private hospitals. We have recommended private hospitals that the government approved hospitals are there. We are paying. I mean, the companies are also paying the insurance.
Any person can pay and take a medical and private hospitals. That's
And that is not about the
But
private.
okay,
No,
arguments are there, right?
No.
One thing, just
No,
one
don't
minute.
stick to that. We should
No,
come
no.
out of that mentality. That's
Well,
what I just
you,
wanted to
you
do.
also need to understand, right? I'm not saying you are right, you are wrong, and
Yeah.
you are right, you are wrong. But need to understand, yes, big companies in the country, they have provided insurance, medical insurance for majority of the workers. But right, 80% of this country, 80% of total workforce are working in small and medium scale.
No, that's right, sir. I'm totally agree with you. I'm not denying.
No.
Actually, I was against her point only government also. That's the only concern I had. නෑ මෙතන ඉන්නකොට සමහර කට්ටිය ගිහලා ඇඩ්මිට් කරනවා ඒක ප්‍රයිවට්ද නැෂනල්ද කියන එක නෑ but definitely they will හොරන වගේ පැත්ත yes
ඇඩ්මිට් කරාම එයා කියන මෙන්න මේ වගේ ඉන්සිඩන්ට් එකක් වුණා මෙන්න මේ වගේ කොමන්ට් කියලා අර බාරකාරීත්වය යන්නේ ඇඩ්මිට් කරන එක තමයි බාරකාරීත්වය වෙන්නේ. ඒකට එතනදි කරන්නේ මූලික ප්‍රතිකාර දෙනවා ප්‍රයිවට් හොස්පිටල් එකේ. එතකොට එතනදි මතන් වෙන්නේ ඒගොල්ලෝ දීලා ඒගොල්ලන් දැන් හිතන්නකෝ එක්ස් amount එකක් වෙනවා කියලා 1000ක් කරා බේස් වල මෙතර ගන්න කියන්නේ. ඒක එතකොට යාර ගෙවන්න පුළුවන් කියලා බලලා ඊට පස්සේ යා කරන්න ප්‍රයිවට් හොස්පිටල් එකේ ඇම්බියුලන්ස් එකෙන් පාස් කරනවා ගවර්න්මන්ට් හොස්පිටල් එකේ. මොකද ඒක ඩිපෙන්ඩ් වෙන්නේ
economic cost, right? Because sometimes if the person has to pay the, I mean, when you go to the private hospital, right?
No, the charges are really high. So if they can't afford, definitely they will be transferred. Ek avila own a private hospital, they will do it. That's what I just wanted to make a point. Private hospital, they will transfer.
Now
Now, because if you give that, the insurance companies are blacklisting the company. That they are doing it now. So now I'll come to the point. In Sri Lanka, our public transports are really bad. I mean, not up to the standard. We'll say like if they want to reach the hospital, your workplace within the time, definitely you can't. So whatever the available transport, they will get into the bus, the overloaded bus, overloaded trains. There are many instances
we have experienced it now.
Yes. So
for 30 years, the vehicle finally BMW 7 Series now going by bus. Today, from Padwela, 7:45, I reached to the bus hall. But then I realized that the time is not sufficient for me, and then I pick me or something. I came in, so I know the situation.
Yeah.
Right?
So
very bad.
They are actually all the employees are requested to keep their finger or their ID within the time. We'll say 9 o'clock or 8:30. So they have to target their time, and they get into some public transport that is not really safe. Sometimes they come in the footboard, and so if the accident happens within that time period, definitely they should be, paid, because they are not going for their personal gains. One thing is that. The second thing, afterwards, we as employees, we go with tremendous pressure sometimes because we don't finish our work on time, and sometimes the bosses are really stressful. So people are going with so much of stress. We are not paid like other countries, so people have so much of economic troubles. Yeah, which make them more stressful. So till they reach home, they think so many things which related to this employment. So if something happens, after work also, it's sometimes attributed to the work. It's not that they voluntarily go and meet with an accident. So people, they don't like to voluntarily go and get into accidents. So that is also something we really need to look into that. And then after work, if they go for some parties or if they under the influence of liquor, definitely you should not be paid. Even for an accident or whatever the cause may be, you should not be paid because they are taking a chance and they are paid and getting the accident. So for that incident, definitely they should not be paid. And the other thing, like people after work, if they are going and buying their personal needs, to cook or whatever the stuff, definitely they should be considered that is within the course of the work, because you will say if they take the leave and if they can buy the things, they will not wait till late night. They can go to the shopping after 1 o'clock or 2 o'clock, and they can get the things done within the working. I mean, before 5 o'clock or 6 o'clock. So after it's happening, in the sense, they need to prepare for the next day. So within the work period, they can't go and do their shopping. So on their way back, definitely for the next day preparation, they have to get the things sorted out, and they have to be prepared for the next day. So obviously that is also part of their next day work. Otherwise, they can have leisurely, they can have their time. So definitely they should be covered.
Okay, right. Well, thank you very much. Yeah. Right.
Hello, sir.
example, train එකකට මොකක් හරි incident එකක් වෙනවා. ඒ කියන්නේ ඔයා train එක ගොඩ ගිහින් අතරමැදදී ආයෙ ගොඩ බෝඩ් එක මොකක් හරි වෙන incident එකක්. එතකොට අපි එතනදි compensation ගෙවනකොට දැන් අපි සාමාන්‍යයෙන් ඒ වගේ දෙයක් කරනකොට පොලිසිය entry එකක් දානවා. මේ මෙහෙම දෙයක් කරා මෙහෙමයි කියලා. එතකොට එතනදී කියන්න බෑද එයා මේ කියන්නේ හරියට යන්න ඕනේ. කියන්නේ එයා දැනගන්න ඕනේ ෆුට්බෝඩ් එකේ යන්න බෑ. එහෙම නීතියක් නෑ ලංකාවේ. එතකොට එයා මේ පරිස්සමෙන් යන්න ඕනේ.
මෙහෙමයි. හොඳට මතක තියාගන්න. මේ ඩෙෆිනිෂන් එක පළල් කිරීමත් එක්ක ambiguities ගොඩක් තියෙනවා. With the broadening of the you have when okay, right. You may discuss later, right?
No, this is regarding insurance.
Okay. So තේද තව ටිකකින් මේක ඉවර වෙනවා. හරිද? එතකොට මාන කවන්න නැගෙන්නේ. මේ හදලා තියෙන්නේ. හරි. එහෙනම් මේගොල්ලෝ හරි. අපිට කලින් යන්න ඕන නම්
hello sir.
හරි හරි මම මේගොල්ලොන්ට බොන්න කියන්නේ එවන්න ටක. දැන් මේකේ මේකත් එක්ක වෙලා තියෙන්නේ දැන් වැඩට එනකොටයි right වැඩට ගෙදර ඉඳලා වැඩට එනකොටයි වැඩපළේ ඉඳලා ගෙදර යනකොටයි accident එකක් වුණොත් ඒකත් මේ පණතෙන් ආවරණය වන්දි ගෙවන්න ඕන. So this has created the definition. I'm not saying this wrong, right? But however, it has created many ambiguities leading to argument at the workman compensation office, right? Lot of argument. It involves cost to the company. It involves cost to the affected person. It is cost to the society. It costs to the national income. I mean, the economy, the prosperity of the economy. So what we need to, if we look at, other countries, examples, like, the developed countries, Europe. So they have simplified everything while protecting the worker. While protecting the worker. They have simplified things while fully protecting the person. They have medical, they have, accident insurance, coverage, everything. Here, we have created many problems. So what my understanding is, okay, we need a piece of legislation, right? Mandating the employer to pay, to insure their workforce, right, based on a certain formula. At the same time, the money should be taken, insurance in the sense we should not allow, my opinion, we should not allow the company to insure individual person, right, with the whatever the company. It should be a fund. There should be a fund. Insurance in the sense, a fund governed by a separate body, right? Whether it's a labor department or central bank, whatever, right? EPF division, one organization.
Exactly.
Right?
As you said, like EPF, ETF, there should be a body which covers the insurance policies. We'll say we also contribute as employee also we contribute a certain amount.
Definitely. Even I'm not proposing. We do I mean, we need to have separate bodies like ETF, right? ETF. We can ask, okay, this is the formula. Okay, let it be, right? Let it be. According to this formula, we know that how many people are working, right? You are supposed to, contribute to the ETF fund. Just example, right? ETF. We don't need to have another executive, administrative structure, right? Because of maximum use of existing resources. So there are a couple of people, large number of employees. So as the employer, it's mandatory. You are supposed to pay like ETF and ETF. This amount has to be contributed each month, right? So then, one met with an accident, the company certified and everything, they will examine, right? Pay from the fund to the person. Pay from the fund. Then these ambiguities and lot of headache to the business people.
No need to go to the government.
No need to wherever you go, right? So then that is kind of a thing, think from a broader perspective, right? Now look at how many. This is also social protection and social security. How many institutions do we have? We have agrarian, insurance. Pensioners and insurance fund. Like the social security board. We have social security board. Some other, institutions looking after social security. PPP, private provident fund, right? And the ETF, EPF. How many institutions? In other countries, all like in Asian countries like Indonesia, it is named as Katenaga Karjan, right? The organization. 5,000 workers are working, coming under that separate, body institutions comes under the Ministry of Labor. Always the chairman, definitely additional secretary level person from the Department of Labor. They have, the private sector participation and trade union participation, the NGOs participation. They, sit and take decision. They have, different schemes for paid workers who earn salaried or, paid worker, paid in the sense, yes, paid workers, right? And unpaid, self-employed. They have separate scheme for self-employed. They have, for paid employee, employer has to contribute, must. So on account workers, they have created many platforms, online platforms for them to, contribute. Finally, their marketing is very good marketing. So, persons of even small, they have to contribute a small amount of money, right? But later, met with an some accident or something like that, they are getting sufficient amount of money because the money in one basket sources are from coming from different sources, and then the quantity is very big. They invest in different portfolios, earn a lot of money. So then contribution also, the payment also, the benefits also very high. We have separate institution here, the other one is here, right? Small pieces. EPF is the biggest one, but the problem with EPF is what? Problem with EPF is
they don't invest properly.
Yeah,
One thing.
only I'm not asking to, proposing to invest in the share market. No, but it has been manipulated. It is being manipulated. So, but different, like road, highways. Why we are going behind Japan and other countries asking loans? They have money.
But the trade unions and political parties, they will never allow
Yeah,
this
that is
to
the problem,
happen.
right?
So even the insurance policy, the previous government, I'm not supporting any government, they really genuinely try to bring it, the insurance policies to every employee, but they didn't allow it to happen.
Because I tried my level asking some professors to come here from Korea, right? And but finally what happened? Yeah. Yeah.
But still, they wanted to implement that insurance policy, but
No, even my intention, if I can take a decision, right? If I have sole authority, definitely I will close the workman compensation office. And before that, well established, insurance system should be created. Then that is how, because separate people, the competent people, they will look at and the payment will be made. Employers just contribute small amount. It's not big money. But මේක වෙලා තියෙන්නේ මොකද දන්නවද? අපේ රටේ we always think, personalize.
Like it's a private sector එක ගොඩක් මේවා කරන ලාභ උත්පාදන තමයි private sector companies ගොඩක් කරන්නේ. එතකොට එතනදී වෙන්නේ ඒගොල්ලෝ ගොඩක් employee කෙනෙක්ට බලන්නේ නැහැ. සේවකයෙක් පැත්තට වැඩි අවධානයක් යොමු කරන්නේ නැහැ. මොකද දැන් යම් දෙයක් සේවකයෙක්ට උනොත් එහෙම ඒගොල්ලෝ බලන්න පුළුවන් තරම් කට් කරලා එයාට දෙන්න තියෙන ගාන අඩු කරලා තමයි එන්න බලපන්. සමහර කම්පැනිස් තියෙනවා employee welfare වලින් හොඳට කරනවා. ඒකට සල්ලි කියන දේ වේදන් වෙනකොට කියනවා මෙච්චර ගෙවන්න එපා. ඕගොල්ලෝ මෙන්න මේක නොගෙවෙන්න try කරන්න.
Sustainability ගැන හිතන්නේ නැහැ.
මේක employee sustainability ගැන හිතන්නේ නැහැ. long term plan එකකුත් නැහැ. මොකද ඒක employee කලකිරෙනවා. ඒක එතනදී වෙන්නේ කම්පැනි තමයි පාඩු වෙන්නේ.
කල්චර් එකනේ ප්‍රශ්නේ තියෙන්නේ.
කල්චර් එක ලංකාවේ ඉන්න කල්චර් එක.
ඔව් ඒ කියොත් එහෙමයි හාමුදුරුත් එහෙම බෞතරයක්. හරිද? හොඳ මිනිස්සු ඉන්නවා. But most ඒකයි කියන්නේ, in such a country you need to have system. System තියෙනවා. It reduce cost. It reduce manipulation. Hanky banky back. Well developed systems. For example, let me tell you, in Europe countries, if you are residing in Switzerland or somewhere in Europe countries, right, you are not supposed to pay for medicine. You have insurance card, medical card. So you have to contribute monthly. So you go to, the doctor, say the private doctor, you go to the private doctor. Right? If you go to private doctor here, you understand what
yeah,
is happening.
You can't go to the consultant directly. You have to go to your GP, your family doctor, your area doctor.
No, even you go for a consultancy, it is possible, right? But you are not supposed to pay to the doctor. See, the doctor will prescribe you, give the prescription, and say his charge is, say, $100, right? $100, private practice, $100. Insurance, then the doctor has to, request from the insurance company. Insurance has been linked to income tax, right? Whatever doctor, make the request, it goes to the income tax as well. So, see the tax gun, private clinic, 60% tax. It's right. So, thank you very much. Is it okay to wind up? Contribute so you contributed well, and
Sir,
what
hello,
is
sir.
one more thing you need to understand is whatever written in the legislations, when it comes to practical situations, there are many problems. So you have to face to the problems and argue. Then only you will having thorough knowledge. So thank you very much,
Hello,
the
sir.
participant from online, for
Hello,
being
sir.
with me, and
Hello, sir.
have a good day.
Can you hear me, sir? Can you hear me, sir?
Yes. Just one second.
Hello, sir.
Hello.
Sir, can you hear me?
Yes, I can hear you.
And I have another thought about the amendment. Shall I say to you, sir? Is it okay?
Yeah.
Regarding
Tell me.
and this is basically ILO. ILO consider about the social security. As per the Article 22, it says that every member of the society has right to live. So society security is there.
Referring to ILO Convention 102?
Yes. Yes, 102, and from there we have
There are 9
information.
branches, including workman compensation.
Yes, so from that we got some points to amend this one. For an example, think about a person who start working.
Uh-huh.
Person is start his job in the morning, and he is on the way, and from the amendment it covers that prior to the work and after the work. If something goes wrong, it will be secured, right, sir? Then as per the ILO also say that
As per the ILO convention, because
Human rights.
we can refer to ILO convention 103, right? It is coming according to the ILO convention, working, coming to work and going back to residence also covers, right? But
Yes.
the problem here is it is as the same way, right? We have amended our the workman compensation ordinance, and that is good, but the consequences, right? Yes,
Yeah.
we have to broaden
Yes, sir.
the definition, right? What you are
Yeah.
saying is, the referring to ILO convention. Yes, there are, as I told you, there are 9 branches as far as social security is concerned, right? ILO convention. That is
And
good because that definition captures, in par with the ILO, this definition in par with the ILO definition as well. But the
and sir,
problem here is, we don't have system in
yes,
other countries, right? Lot of countries, they have very good system. Our, as we don't have very good system.
question එක අහන්න ඔයාගේ.
Sorry.
Hello, sir. Sir,
Oh.
Sir, we need to implement a system. For an example, for the medical ground, we can get the certificate from hospital, and it need to be uploaded online. And for the incident reported for the police department, we can get uploaded.
All
and
those
things
to be linked, right?
Yes, integrated
Police,
system.
hospitals and workman
Yes.
compensation, every should
And
be linked, right?
Yes, link. And same time, if some person has committed a accident or something, then somebody has to pay. Definitely, we should implement a insurance system for all. It should be more
okay.
18 years old, and start from 18 years old, and then everybody has to right to pay if some incident occurred. Then they can safeguard their surrounding, so they will be protected themselves. So
Definitely, you are correct, right? Definitely,
government
you are
do
correct.
not want to give any percentage for this, because every body take care of their self, sir. So that from there we
Definitely. I
can
mean,
do.
everybody, because accident is a cost, right? But somehow someone has to bear the cost. Therefore, the risk must be pooled. Right? By then we can pay by way of insurance. You are correct, right? Thank you very much. And
Welcome,
anything
sir.
else? Did you learn something?
Yes, sir. And other one question, sir, regarding on if somebody has made with an accident and he comes with a medical report, 3 months medical reports. What should be the proper guidance to mitigate that issue from the HR perspective with regard to applying the labor law? Since during the medical conditions, can we pay salary, or are we going for this one?
It's like this, if it is in relation to accident or health, right?
Yes.
Covered by this ordinance.
Yes.
Definitely, it has to be paid, right? Until the person is recovered. It is up to the medical doctor to say, how many days or how many months, right? The worker has to rest, right?
Yes.
Then this column, the last column, half monthly compensation for temporary disabled of workman. This is the amount to be paid based on the salary range, right? So based on the salary.
Yes.
This is the payment. But if the health matter, ill health, if the ill health cannot be attributed to the injury, then there is no requirement for the employer to pay. Right?
Yes.
Are you getting my point? As
Yes.
per the labor law,
Mm.
there is no what you call medical leave for the private sector people. There
Yes.
are, it's up to the company, but by law, only they have, right, a casual and annual, right? Only annual for workers covered by the wages board's ordinance. Then if the person is not reporting to work based on, the medical condition, medical reason, what the employer on sympathetic ground, employer can pay, certain amount of money, basic or whatever. It is up to the company. But if the person has earned leave to be used, I think, better to grant, the leave, then
Right,
the
sir.
payment has to be made. Otherwise, if the person does not have earned leave to be used, then if the person, and again the person is not attending to work, right, due to ill health, employer is not liable to pay. But health matter, has arisen as a result of accident, as a result of work, then yes, the employer is liable to pay. Is it clear?
Yes, sir. And sir, same time, during those kind of a situation, from the company they will pay the salary, and from the employee side he will get from the insurance as well.
Yeah.
So will
But whatever the paid or payment made by the employer can be deducted from the insurance money.
okay, sir. Right, sir.
Right.
Right, sir.
Okay.
Thank you, sir. Thank you, sir.
Right. Okay.
Thank you very
Thank
much,
you
sir.
very much. And I'm winding up.
Hello. Hello.
ඒ වයින් අප් කියලා ගියාද කොහෙද?